Okay, welcome everyone. We are live on Facebook, Rumble, Twitter, Twitch, YouTube, and Telegram. This is a very special premiere presentation of Who Framed Roger Rabbit, the Roger Hillygus case, a forensic timeline analysis with video and corresponding article plus sources for user independent verification. With that being said, let me read our disclaimer and then we will begin. The views expressed on this show are expressly the views of the speaker and do not necessarily reflect the views, beliefs, or opinions of News4US.WORLD, its hosts, broadcasters, or affiliates. Remember, folks, always use your own discernment when viewing. We encourage our viewers to think for themselves. All right, folks. So before we get started and get into the article and the video timeline, I have a special little monologue, a modified, updated, modern version of a speech that I think is really powerful, and it's originally from Charlie Chaplin from the movie The Great Dictator. I've modified it for modern times, and I think it's more relevant now than ever. And let's begin. Let me read that for you, and then we'll start the analysis. I'm sorry, but I don't want to be an emperor. That's not my business. I don't want to rule or conquer anyone. I should like to help everyone if possible. Jew, Gentile, black man, white. We all want to help one another. Human beings are like that. We want to live by each other's happiness, not by each other's misery. We don't want to hate and despise one another. In this world, there is room for everyone, and the good earth is rich and can provide for everyone. The way of life can be free and beautiful, but we have lost the way. Greed has poisoned men's souls, has barricaded the world with hate, has goose-stepped us into misery and bloodshed. We have developed speed, but we have shut ourselves in. Machinery that gives abundance has left us in want. Our knowledge has made us cynical, our cleverness hard and unkind. We think too much and feel too little. More than machinery, we need humanity. More than cleverness, we need kindness and gentleness. Without these qualities, life will be violent and all will be lost. The computer and internet have brought us closer together. The very nature of these inventions cries out for the goodness in men, cries out for universal brotherhood, for the unity of us all. Even now, my voice is reaching millions throughout the world, millions of despairing men, women, and little children, victims of a system that makes men torture and imprison innocent people. To those who can hear me, I say, do not despair. The misery that is now upon us is but the passing of greed, the bitterness of men who fear the way of human progress. The hate of men will pass, and dictators die, and the power they took from the people will return to the people. And so long as men die, liberty will never perish. Soldiers, don't give yourselves to brutes. Men who despise you, enslave you, who regiment your lives, tell you what to do, what to think, and what to feel, who drill you, diet you, treat you like cattle, use you as cannon fodder. Don't give yourselves to these unnatural men with machine minds and machine hearts. You are not machines. You are not cattle. You are human. You have the love of humanity in your hearts. You don't hate. Only the unloved hate. Only the unloved and the unnatural. Soldiers, don't fight for slavery. Fight for liberty. In the 17th chapter of St. Luke, it is written, the kingdom of God is within man, not one human nor a group of humans, but in all humans, in you. You, the people, have the power to create machines, the power to create happiness. You, the people, have the power to make this life free and beautiful, to make this life a wonderful adventure. Then in the name of freedom and liberty, let us use that power. Let us all unite. Let us fight for a new world, a decent world, a world that will give men a chance to work, that will give youth a future and old age a security. By the promise of these things, brutes have risen to power, but they lie. They do not fulfill that promise, and they never will. Dictators free themselves, but they enslave the people. Now let us fight to fulfill that promise. Let us fight to free the world, to do away with national barriers, to do away with greed, with hate and intolerance. Let us fight for a world of reason, a world where science and progress and common sense will lead to all men's happiness. Soldiers, in the name of freedom and liberty, let us all unite. I hope that reached everyone and everyone enjoyed that because I think it's powerful. And so with that being said, let me begin our coverage. Was I coming in clear on their alley? Did I sound okay?
Yeah, it sounded excellent and it got me in the heart.
Nice. Good. That was what I was aiming for, to inspire people.
Yeah, very inspiring.
I just have to fix my OBS camera. It's not functioning properly. It doesn't want to work. It's freezing up. There we go. Okay, that's better. Okay. All right, so we're going to cover the video. We're going to watch the video first, and then after the video, and that's so the viewers who haven't seen it yet, prior to this, will be able to have the chance to see it during the live, and then we're going to be going over the article, which is pretty massive in and of itself. But anyways, so let me just do our little the little introduction text here before we get into the video, so people understand the context of how we present our case analysis. In this forensic analysis, I will be presenting an evidentiary video timeline of the chain of events in chronological order. This real-life Who Framed Roger Rabbit story and forensic timeline analysis is the abridged short version. I will be putting together an extended, in-depth version which will cover all of Roger's exculpatory evidence that the courts have been ignoring or not allowing in discovery, as well as all of Roger's Nevada Supreme Court filings and the rejections resulting from this, which is what led to him seeking his right to a jury and file it forever. I will also include the horizontal scrolling source table as shown below the video, just as we did for our launch article, Pandemic Indoctrination, Fact Check, and In-Depth Analysis. This format of presenting evidence is unique to NEWS4US.WORLD and can be extremely useful for user and/or reader independent verification of evidence. No scrolling needed to access the sources. They will automatically appear underneath the video as it plays and reaches each timecode for the corresponding source. It can also be used to find where you last left off in the video by unchecking the auto scroll checkbox, then clicking the timecode link above the corresponding source you are trying to find, and it will automatically jump to that timecode in the video and resume from there. Let us begin our analysis of this case, starting with the video timeline, followed by the corresponding article. One of the biggest high-profile cases I've had the honor of being involved with in exposing the corruption that exists in our family court and guardianship court systems is the Angela Freiner case out of St. Louis, Missouri. It had many of the same kind of bad court actors, which also used the same kind of tactics and legal loopholes to accomplish case fixing in order to achieve their agenda. As you will also see and recognize in this case, although this is a guardianship and probate court case in regards to the Hillygus family, make no mistake, they are using the same playbook as was used in the Angela Freiner case. As we get into the details of the timeline, and aspects of the case that are critical to understanding the nature of this racketeer-influenced corrupt organization, or RICO, and how it is connected to the Angela Freiner case, as well as many others as of yet not named, you will clearly see the pattern of organized criminality through the family, guardianship, and probate courts, and how all three aspects of this racket are working hand in glove to achieve their end result. What is their end result, you ask? Well, in the family and CPS court system cases, they are unjustly removing children from loving and non-abusive parents and sending them to the abusers. Why on earth would a court system do this? Simple. They monetarily incentivized the Title IV grant money. In layman's terms, they get more federal funding per child that they have in their system. In Angie's case, the family court trafficked her daughter across state lines to a girls' boarding school known as Trinity Teen Solutions. Trinity Teen Solutions was known and suspected to be involved in child labor and human trafficking, and as recently as August 2022 was shut down due to an open lawsuit for child labor and human trafficking by multiple former students. In many of the probate and guardianship court cases, they are stealing people's assets, trusts, and property. And in many cases,
are intentionally using negligent and or understaffed care facilities whom are also over-medicating their elderly patients and owners of said assets, trusts, and property in order to hasten their demise. You'd be surprised how many times these cases involve spiteful or resentful family members of those whom are being unjustly and unlawfully targeted by these bad court actors. For the purposes of expediency and efficiency, this forensic timeline analysis will stick to the most relevant facts, evidence, and claims as they pertain to the Roger Hillygus case. However, any additional sources or evidence not prominently featured in the timeline analysis will be available to access through our unique horizontal scrolling source table directly below this video. In addition, this analysis will be done in the same common law fashion, i.e. precedent, as in a court of law, when having to meet the burden of proof standards. At the end of this analysis, you will have a deeper and more thorough understanding and grasp of corruption in the courts and how they operate from this modus operandi. You may view our reporting standards on how we cover these cases on the NEWS4US.WORLD Terms of Service page under the Code of Conduct section.
I do solemnly swear that I will support, protect, and defend the Constitution and government of the United States and the Constitution and government of the State of Nevada against all enemies, whether domestic or foreign, and that I will bear true faith, allegiance, and loyalty to the same, any ordinance, resolution, or law of any state notwithstanding, and that I will well and faithfully perform all the duties of the office of a Senior Justice of the Peace of the Nevada court system on which I am about to enter. So help me God.
This all started on October 1st, according to Roger's application for a temporary and or extended order for protection against domestic violence against his sister, Robin Renwick. The application was filed on December 24th, 2013 at 11:09 and 49 seconds a.m. Let's take a look at some of the claims Roger makes in his application for a TPO. Narration by Robin Austin.
October 1st, verbal abuse, threatened to rain down legal and financial hardship, viciously and vehemently refused to remove her name from parents' joint U.S. bank account, recommended by attorney Steve Moss, while in his office. November 30th, threatened over phone to deny me access to residence at 2685 Nob Hill Drive. She illegally enters residence and room and removes various personal property, medical records, legal documents, journals, files, miscellaneous mail, etc. Admitted this to Washoe County Sheriff's Office, WCSO. Unauthorized reopening of parents' U.S. bank joint account. Removes $3,700, causing account to be overdrawn. Later apologizes for the wrongdoing. My wife and I called Washoe County Sheriff's Office, WCSO, non-emergency, and asked how to obtain a temporary protective order. December 2nd, she places a 911 call to WCSO, Washoe County Sheriff's Office, and falsely reports to dispatch that, quote, my brother is stealing all the personal property from residence 2685 Nob Hill, 9 p.m. Wife and I stopped by WCSO, Washoe County Sheriff's Office, to talk about threats and harassment while at Christmas dinner at Lakeside Manor. It was recommended by Washoe County Sheriff's Office to file temporary protective order, TPO. December 20th, she calls 911 emergency dispatch to Washoe County Sheriff's Office. Quote, my brother is illegally residing at 2685 Nob Hill and will not vacate premises. She was out of control, abusive, screaming, get the fuck out of here and take your dogs with you, or I will have all of you permanently removed. After Washoe County Sheriff's Office Deputy Vanderwall and Coos and others leave, She continued to invade my privacy. December 23rd, she attempted to gain access to 2685 by jimmying door locks, checking windows, told me previously she would gain access with the help of a locksmith. I'm fearful if she gains access to the residence, I have firearms and money in the home.
Roger's original application for a TPO gets dismissed without any due process or consideration for his evidence.
If either H. Eugene Hillygus or Susan L. Hillygus shall die, or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee. On the death of both settlers, or upon the incapacity of the surviving settler, Roger H. Hillygus is appointed as successor trustee. In the event the above identified successor trustee is unable or unwilling to serve as successor trustee, Robin R. Hillygus Renler shall serve as successor trustee. In witness whereof the settlers set their hand and seal, and the trustees have caused these presents to be executed on the day and year first above written. Settlers H. Eugene Hillygus, Susan L. Hillygus. Trustees H. Eugene Hillygus, Susan L. Hillygus. State of Nevada, County of Washoe. On this 24th day of August 2011, H. Eugene Hillygus and Susan L. Hillygus, as settlers and trustees, known or proved to me to be the same persons whose names are subscribed to the foregoing instrument, personally appeared before me and acknowledged that they executed the foregoing instrument freely and voluntarily for the uses and purposes herein expressed. Stephen C. Moss, Notary Public. All terms of Hillygus Family Trust, restated, dated August 17, 1993, shall remain the same except for the following. 1. The existing terms of Section 9.1.2 are deleted in their entirety and replaced with the following. 9.1.2. If either H. Eugene Hillygus or Susan L. Hillygus shall die or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee. On the death of both settlers, or upon the incapacity of both settlers, or the surviving settler, Adam Clark is appointed as successor trustee. Dated this 11th day of June, 2014. Take note of the date here, specifically the year, It says, dated this 11th day of June, 2014, from the law office of Todd L. Torvinen, chartered, Todd L. Torvinen, Esquire, attorney for Robin Renwick. Certificate of Service. Pursuant to NRCP, Nevada Rules of Civil Procedure 5B, I certify that I am an employee of the law office of Todd L. Torvinen, and that on June 11, 2013, I served a copy of the foregoing document on the parties identified below by using the ECF system, which will send a notice of electronic filing to the following: Steve Moss, Esquire, Michael Springer, Esquire. Take note of the date here on the certificate of service, specifically the year. It says June 11th, 2013. Typo? Objection to petition regarding administration of revocable trust. Roger E. Hillygus, by and through his attorneys Don L. Ross and Lauren D. Burkich of the law firm Woodburn and Wedge, hereby submits his objection to petition regarding administration of revocable trust filed by Stephen Moss, purportedly on behalf of H. Eugene Hillygus. This objection is based upon the following memorandum of points and authorities. Opposition in part to oral motion for the appointment of guardian ad litem. Memorandum of points and authorities. H. Eugene Hillygus, hereafter Gene, and Susan L. Hillygus, hereafter Sue, executed the trust agreement for the Hillygus Family Trust on August 17, 1993, attached hereto as Exhibit 1. Section 9.1.2 of the trust agreement provides as follows. 9.1.2. If either H. Eugene Hillygus or Susan L. Hillygus shall die, or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee. On the death of both settlers or upon the incapacity of the surviving settler, Roger H. Hillygus is appointed as successor trustee. In the event the above identified successor trustee is unable or unwilling to serve as successor trustee, Robin R. Hillygus Renwick shall serve as successor trustee. Date 6/12/2014. Dear Steve Moss, it appears as though you are not taking my verbal request to you over the phone, discharging you as my attorney. Seriously, let me refresh your memory about the events of that call. My son, Roger Hillygus, the successor trustee of the Hillygus Family Trust, and I hand-delivered to your office secretary, Cynthia, an original hand-signed letter by Roger discharging you as the attorney representing me and the Hillygus Family Trust. At that time, we both told Cynthia to send us any and all personal property and the complete file along with the final bill. You called me the next day and we spoke about this, and I informed you during that phone call that I no longer need or wanted you to represent me or the trust. You told me that pay the final bill would be $2,000. I am confirming the discharge letter written by Roger. I agree with the terms and conditions of the letter. I am, however, disappointed that you are continuing to represent me after we mutually agreed to terminate our relationship. I realize that you believe me to be incapacitated and that you think you are protecting me from my son, Roger Hillygus. Nothing could be further from the truth. He is the successor trustee and the one I have always wanted to be placed in that position. So please consider this your official notice discharging you as my attorney. You are to cease and desist from any further actions, hearings, or petitions with the court on my behalf, or by representing any family member. Respectfully yours, Herbert Eugene Hillygus. Recommendation for order assuming jurisdiction over trust, order setting pretrial conference. The Commissioner held a duly noticed hearing on June 19, 2014, upon the petition regarding administration of revocable trust filed by H. Eugene Hillygus through his counsel, Stephen C. Moss, Esquire. Counsel Moss appeared at the hearing. Also appearing at the hearing were the following additional interested parties: Todd L. Torvina.
It's verified. The petition's verified. It's nonsense.
Esquire, representing Robin Hillygus Renwick,
How?
who joined in the petition. Sharon Januzzi, Esquire, representing Roger E. Hillygus, who opposed the petition. Sharon Januzzi, Esquire, representing Roger E. Hillygus, who opposed the petition. Not appearing was Susan Hillygus, co-settler of the trust, nor her counsel, Gordon R. Muir, Esquire, although the court is informed that he is still counsel for Susan Hillygus. The matter is contested. The Commissioner therefore scheduled the parties for a pretrial. The matter is contested. The Commissioner therefore scheduled the parties for a pre-trial conference on July 1st, 2014 at 4 p.m. before Department 4 of this court. The Honorable Connie J. Steinheimer presided. The Commissioner made the following additional recommendations. The court assumes jurisdiction over the Hillygus Family Trust, dated August 17, 1993. The court declines to confirm the appointment of any successor trustee, although the record indicates that the same may have become necessary, based upon the incapacity of both settlers, H. Eugene Hillygus and Susan L. Hillygus. Instead, the pretrial conference date was expedited so as to allow these issues to be addressed soon, if necessary. The court further declines to act upon the oral motions to appoint a guardian ad litem for either settler, and instead allows the opposing party, Roger E. Hillygus, to file his written opposition to that motion. Nothing in this portion of the recommendation, however, constitutes a finding that would bar a party from seeking further relief in this area or in continuing to pursue the pending petitions for appointment of adult guardians if the same becomes necessary or appropriate. Herbert Hillygus obituary. Herbert Eugene Hillygus, June 16, 1933, August 24, 2015. Herbert Eugene Hillygus passed away on August 24, 2015, at his home after a brief battle with cancer. He was 82. Jean was born in Santa Clara, California in 1933 to Stanley and Josephine Farrell Hillygus. Growing up, Jean spent time in Yerington, Nevada, Paso Robles, Templeton, and Jackson, California. Jean attended Taft Junior College, where he played basketball, football, and tennis. He graduated from Long Beach State with a Bachelor of Science and a master's degree in education. He was employed by Montebello Unified School District until he moved to Reno in 1972. Jean had a diverse career which began in Reno as a counselor at Reno High School. He taught and was a dean at Truckee Meadows Community College, an advocate for the WCSD Administrators Association, and also a sales career at Dieter Lighting. He was a member of the Washoe County School Board and Reno Rotary. Jean was an avid outdoorsman, an educator, and people person. He always greeted everyone with a smile, never met a stranger, and he loved to dance. His numerous hobbies throughout his life included fishing, hunting, camping, and spending countless hours enjoying the outdoors and nature. He and his wife, Sue, enjoyed raising and riding horses and ran a successful horse boarding business for many years. They were both members of the Nevada White Hats Association. He is survived by his wife, Sue Hillygus, sons Randy Hillygus, and son and daughter-in-law, Roger and Debbie Hillygus, daughter Robin Renwick, grandchildren Darla Clark and her husband.
Adam Clark? Adam Clark.
Wait, Adam Clark? Could this be the same Adam Clark appointed as successor trustee in the First Amendment to the Hillygus Family Trust document?
Adam Clark?
And Landon and Sophie Renwick, great-grandchildren Seth and Gavin Clark, and friend Sammy Brooks. A celebration of life is scheduled for Sunday, September 27th at 2 p.m. Walton's Funeral Home, Ross Burke and Noble Chapel, 2155 Keatskey Lane, Reno, Nevada. All are invited to attend a reception to follow at 11380 Parma Court, Reno, Nevada, 89521. Take note of the parcel number here, 552-171-04. This will become relevant later in the timeline. Homestead document dated 11/05/2015, 12:06:37 p.m. Case number PR 14-00025/GR14-00159 in the matter of the Hillygus Family Trust, dated August 17, 1993, in the matter of the guardianship of the person and estate of Susan L. Hillygus. Notice of right to a jury being applied to this case per the Nevada Constitution, Article 1, Section 3. Inviolate for
Sec. 3. Trial by jury, waiver in civil cases. The right of trial by jury shall be secured to all and remain inviolate forever, but a jury trial may be waived by the parties in all civil cases in the manner to be prescribed by law, and in civil cases, if 3/4 of the jurors agree upon a verdict, it shall stand and have the same force and effect as a verdict by the whole jury, provided the legislature by a law passed by a 2/3 vote of all the members elected to each branch thereof may require a unanimous verdict notwithstanding this provision.
forever. Legal arguments. Arguments why the state, the court, and the petitioners feel they are justified and compelled to keep Susan L. Hillygus incarcerated and isolated in a private locked facility, denying a mother-son relationship. Case number PR 14-0025, case number GR 14-0159, Department number 7, in the matter of Hillygus Family Trust, dated August 17, 1993, PR 14-0025, in the matter of the guardianship of the person and estate of Susan L. Hillygus, mother, GR 14-0159. Jury verdict and options available to the court. Honorable Judge Egan Walker. This is notice to the court that a jury has examined the evidence which was approved by the opposing counsels via acquiescence, and they have determined and stated in their unanimous verdict that there is not clear and convincing evidence that familial rights must be terminated to protect the parents, and that all orders of this court that interfere with familial rights, as stated in the Hillygus Family Trust documents, are void and unenforceable. Options: 1. Order the immediate release of mother to son's custody and conform to all trust documents as ordered. 2. Convene your own jury to decide this matter. No law prohibits a jury. 3. Or provide findings of fact and conclusions of law explaining how this court is not subject to the authorities listed in paragraphs 1 and 2 of the attached notice to judges. All other legal authorities are subordinate to the Nevada Constitution, inviolate, and the jury has made their decision. The court has until close of business, Friday, July 26, 2019, to respond to preclude actions described in subsection 4.4. Affirmation: Nevada Revised Statutes 239, no Social Security numbers are anywhere. Dated this 19th day of July, 2019. Signed, Roger Hillygus, son. Case numbers PR 14-0025 and GR 14-0159. Second Judicial District Court, Nevada, County of Washoe. Guardianship and estate of Susan Hillygus. Judge Egan Walker. Reference documents for and against termination of familial rights dated June 25, 2019. Documents meet the confidentiality requirements of 42 United States Code subsections 5106A. This court has been duly noticed of defendant's right to have a jury decide this case. The judge declined to furnish a jury, leaving that responsibility to defendant per the attached notice to judges. The above-mentioned documents have been presented to an 8-person jury panel, and they have produced a unanimous verdict as follows. 2. Jury verdict. The state has not met the standard of clear and convincing evidence that the son is dangerous or abusive to his parents, such that the state is compelled to intervene in this family. Wherefore, all orders that diminish the force of law established by the family trust documents are void and unenforceable. This verdict is effective immediately and may be overturned only by a jury provided by the court under its authorities per Article 3. The court has discretion to utilize its own jury at any time. The right to a jury remains inviolate regardless of the results of the court's discretion. 3. This court now has the discretion to choose any of the options in Section 4, page 2 of the attached notice to judges 4.2 issues orders that conform to jury verdict. Return mother. 4.3 convene the court's own jury. 4.4 deal with defiance of the Constitution noted. 4. Seventh Amendment. No fact tried by a jury shall be otherwise re-examined in any court of the United States. No place does it say, quote, a judicial order may not be re-examined by a jury. Only the word, quote, inviolate controls in this matter. Notice of judgment. The encumbrance of 2685 Nob Hill Drive, Reno, Nevada, 85906. Presiding Judge Egan Walker. This is notice to all concerned that the real property, 2685 Nob Hill Drive, Reno, Nevada, 85906, is subject to sole and exclusive ownership by the Hillygus Family Trust, of which Roger Hillygus is the sole successor trustee. All orders to the contrary and prior to the verdict rendered on July 11, 2019, are void and unenforceable. Any actions or transfer of title to this property without the current expressed written consent of the trustee, Mr. Roger Hillygus, may either be negotiated to the satisfaction of the trustee or a satisfactory resolution shall be adjudicated in a court of law.
Absolutely.
Okay.
She put me in charge of her as her power of attorney. I'm her successor trustee to her trust.
Okay.
I'm her son.
Okay.
I've cared for her already, and I'm going to continue to care for her. I'm retired fireman.
Okay. Perfect. How long has she been in the care facility?
3 years.
3 years.
After I had everything in
concerned
order.
that the facility is not going to want you to take her?
A little bit.
Okay, why is that? That's what I guess I'm getting at.
Because when I was there visiting her with a witness, it was all videoed.
Gotcha.
I was holding her hand, like loving my mother.
Yeah.
And they said, you have to leave. You're upsetting your mother. And I said, what are you talking about?
Okay. Okay.
And they said, well, we've called the police. I'm like, why? I'm sitting here with a witness. It's videoed. She's loving that I'm there holding her hand. I'm not upsetting her.
Yeah, yeah.
And I cared for my mother for 3 years.
Absolutely.
And I've lived with her for, a lot of my life, and I want to continue to care for her.
Okay. Perfect. Did she voluntarily go into the care center, or was she placed there by somebody?
They placed her in there.
Who placed her?
The guardian that's been now removed from the jury.
Oh, okay. So there was another guardian involved.
There was one, yeah.
Okay. And they placed her there.
Yep.
And so was there a dispute between you and the former guardian about who should have guardianship of your mother?
There was false allegations made against me, but they were investigated, and I was proven to be
Gotcha.
There was no allegations that were shown to have affected me.
Okay.
It was investigated. I wasn't convicted. I wasn't arrested. I didn't do anything wrong. I'm not a criminal.
No. Okay.
I'm a
So
retired
what's the
public servant.
judgment that you got? What's the judgment say?
It says that I'm her. The original trust documents are back in place, which I have, and the original power of attorney, and that all the orders from the court are null and void and unenforceable. The jury verdict controls the position that I have with respect to taking care of my mother.
And where is Stone Valley, just so I know in case they call us for some reason? All right, so what brought you down here? I mean, I understand you want a stable standby. Obviously, we don't do that unless we have some reason. Because we're not here to enforce these court orders. I mean, we don't. And why we would even get involved, I have no idea. Normally, the civil deputies over at the courthouse, if there's a judgment from the court, it gets handed to them, and the civil deputies handle it. So I don't know. I mean, the police department, we don't enforce any civil orders, period. And obviously, you're there to get your mother.
I'm trying to come to you guys to explain to you that I've got all the authority to do this.
Like I said, we're not involved. We don't get involved in civil judgments, period. Either side. I don't even care what the judge ruled. The judge ruled that you have full power to walk in there and take the whole facility. That has nothing to do with us. That's a civil judgment. The government has no interest in that, so why would we get involved? So, what I'm saying to you is, if you get up there, I would bring all your documents. I wouldn't just walk in there and grab her. I'd go see the management of the facility, show them your documents, explain to them rationally, here's my plan, here's what I'm doing, this is why I'm doing it, this is all the documentation that I have. Can you help me fulfill the orders of this so I can get my mom?
Every time I'd gone to see her, there was something that she wasn't being taken care of.
Okay.
And one-on-one care of a son versus one person with 17 people.
Oh, I hear you. Absolutely.
Every time I went there was issues with my mother not being cared for.
Yeah.
So, with Susan's meds, is there anything on this list that, if not taken as prescribed, is life-threatening?
She has Ativan, and Risperdal.
Can Risperdal cause death in the elderly? Risperdal has been shown to increase the risk of death in elderly patients with dementia. More elderly dementia patients have died from pneumonia, cardiac failure, and stroke, while Risperdal and the increased risk were not related to the dose amount or how long the medication had been taken. Though the exact cause is unknown, patients with dementia may be more at risk as they are unable to report severe symptoms. Because of the number of deaths, the FDA required that a black box warning be added to prescribing information for Risperdal. A black box warning is the most severe warning that can be issued by the FDA and requires that information is printed at the top of prescribing information surrounded by a thick black border.
And this one for the anxiety.
Well, nobody's ever died from anxiety that I know of, but
No,
as
I
far
don't
as
think
any...
so. No, yeah, that's also. It is. Yeah, this is the opposite vitamin D. I don't think so.
Yeah, that's what I didn't think so. I just wanted to double check with you.
No.
Okay.
This is just for anxiety.
Right. Okay. Thank you.
I need you to call down there. 925,000. Try to get back through to his medical system. I need a prescription of lorazepam for that resident.
230.
Lorazepam. Important warning. Lorazepam may increase the risk of serious or life-threatening breathing problems, sedation, or coma if used along with certain medications. Tell your doctor if you are taking or plan to take certain medications for cough or for pain that contain opiates. Example: codeine, hydrocodone, morphine, oxycodone, tramadol. Your doctor may need to change the dosages of your medications and will monitor you carefully. If you take lorazepam with any of these medications and you develop any of the following symptoms, call your doctor immediately or seek emergency medical care immediately: unusual dizziness, lightheadedness, extreme sleepiness, slowed or difficult breathing, or unresponsiveness. Be sure that your caregiver or family members know which symptoms may be serious so they can call the doctor or emergency medical care if you are unable to seek treatment on your own.
At first I thought that he would do that because that's what he's done in the past.
Have them fax
Try to-
us a script for her so that we can get her some medication so she calms down.
He is married?
He is.
He's aggressive. Do you know that the sheriffs had to remove him with the SWAT team from this house?
From your mom's house?
And the sheriffs wouldn't do it without a court order because he threatened that he had guns. And he does have guns. So they go out to Dayton. They need to be aware what they could possibly be walking into.
And we'll let them know.
You know, what's going to happen to my mom after?
Well, she's not on her meds. She's not going to have her meds. She's not going to get changed. I mean, there's crazy stuff going on. This is a copy of what he said. No,
she can barely walk.
So he was dragging her. Not literally dragging her,
I'm
but
surprised he didn't pick her up.
pulling her.
Yeah, I'm shocked.
My
It's
mom,
assigned to a detective.
okay, but do you understand that my mom's life is in danger right now? In danger.
How?
How?
How? She's with your brother.
Have you heard all the stories that we've been going through? That
I understand he has... He may have some...
medications, so you
Okay.
believe that he's
There-
not a hazard.
None of your mother's... No, she doesn't. All of her, no, she doesn't, because I just talked to the med tech because I got a list of her meds, and I confirmed with the med tech because all of her meds are primarily for anxiety, mental health. It's not for, there's nothing physical that if your mom does not take medications, she's going to die from. And I confirmed that with the med tech.
This is the hearing where they got the emergency TPO, which they used as a false basis for persecuting Roger without any recourse of due process and selling the home the day after Roger rescued his mother from Stone Valley Care Facility.
You were aware of what happened, right? Here's a little more. Apparently, he shows up with another goon, and he says, I'm signing Alice out. He goes and gets Mrs. Hillygus, and there's a witness who sees them pulling her, shoving her across the parking lot. He was pinged in Truckee, apparently. Was that this morning or yesterday?
Yesterday.
And this, really, it's a crime. It's a crime of kidnapping. It could be a crime of, that's a Class B felony, probably. Isolation, elder abuse. Well, problematic. Anyway, I don't want to get sidetracked on that. We're here to confirm the property. I'm sorry I interrupted you. The title company is balking at a close any sooner than 30 days because they're afraid that Mr. Hillygus is going to appeal. And I think this is what I'm about to say is true, is a matter of law, that upon sale to a bona fide purchaser in good faith, his cause of action, if any, from this sale is against the trustee and not against the real property. Would you be willing to add that to the order? I'm hoping it gives the title company some comfort so we could get this thing closed sooner.
Any objection to that, Mr. Spitzer?
No, Your Honor.
I would like to time such a
Before we go too far down this, I just want to make sure you don't have any quarrel with this, Mr. Spitzer.
I have no quarrel with that, Your Honor. You do have immediate authority under NRS 159.334 to issue a no contact order under the guardianship statutes.
Mr. Earl?
My only additional thought is under NRS 159.305 that you're dealing with just general exploitation, potential abuse, and so forth, and under those statutes, then likewise the guardian would have authority, or an interested party.
And my thought about a domestic violence protection order is this, is it's registrable. In other words, it'll go into state and national database, and it may have more legs, for lack of a better term, than simply, I of course order that Mr. Hillygus have no contact with a protected person in this case, and that is pursuant to Chapter 159. But let's see if we can establish whether or not there's testimony to warrant a domestic violence protection order. So, ma'am, would you kindly stand, raise your right hand, and take the oath of a witness?
Do you solemnly swear the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God? And they allowed him out thinking that he was the son, and he was allowed to take her out, even though in her file he is not. His name is not on the list of people that are allowed to remove her from the facility. There's a picture in the back room of him, but it didn't look like him.
Let's test that theory with the picture she is referring to and the Reno PD body cam footage of Roger asking them for a civil standby. Let's see what we find with what we have. He sure does look the same to me in the picture as he does in the body cam footage.
Let's move now next to the accounting. With that clarification going forward, I'll approve the accounting.
But under NRS 200.310.2, a person who is willfully, without authority of law, seizes, takes, carries, or kidnaps another person is guilty of Class B felony. To find here in open court today that there's PC with regard to that criminal statute, Class B felony kidnapping.
I think I would do a disservice to the process in this case if I were to step in out of order any more than I already have. Let me be more clear. It's fairly unusual for a district judge sitting with family division jurisdiction, as I do in this guardianship area, to sua sponte issue a protection order. It's been done before. I've done it before. I've never seen a successful challenge to it, and so I believe it's within the jurisdiction of me as a district judge. There is a process, however, in the criminal side. You know, I am now a criminal judge. The law enforcement authorities are going to have to approach the district attorney's office to seek either a warrant for the arrest of Mr. Hillygus, or they will detain and arrest him on allegations of probable cause. It would not be appropriate, I think, for me to opine at this juncture as to whether or not there is adequate probable cause. I just think that would be stepping outside the bounds of my role at this time.
When this first happened yesterday, my clients, both of them, ran into the following milieu. Oh, it's just between a brother and a sister. This is a civil matter, when really it's not. And that's what I'm trying to overcome here. I just want you to understand that, where that's coming from.
Well, I can tell you that in my view, there are a variety of paths that could be taken to recover the person of Miss Hillygus. More specifically, what I mean is I believe there could be an analogous action for a retake warrant, in the way that if a parent secretes a child in a contested custody proceeding, there is a process to allow me to issue a warrant to include the arrest and detention of the parent or the bad acting parent who is secreting.
Wow, talk about violating your judge's oath of office. So much for avoiding the appearance of impropriety, and so much for upholding the state and federal constitution, eh?
It would be a UCCJEA.
Correct.
Okay, and
And
there's an equivalent in...
Well, the UCCJEA applies in Chapter 159
Okay.
cases by definition.
Right.
And so there may be a mechanism for a retake warrant, as it were, related to the person of Miss Susan Hillygus. Apart from that, law enforcement is very aware of this case, I can tell you. It would appear to me there is an active investigation. It would appear to me there is some reason to believe that Mr. Hillygus has kidnapped, falsely imprisoned, and or unlawfully detains the person of Susan Hillygus.
Okay. I think that's all I have before you today, Your Honor.
Anything else, Mr. Spitzer?
No, thank you, Your
Or
Honor.
Mr. Earl?
No, thank you.
Thank you all very much for your time. Ladies, good day
Thank
to
you
you.
very much.
You're welcome.
Jurisdictional disputes regarding children in Las Vegas, helping families throughout Clark County. In Nevada, custody disputes are governed by the Uniform Child Custody Jurisdiction Enforcement Act, which is commonly referred to as the UCJIA. The UCJIA determines whether or not the Nevada court has the ability to consider custodial disputes. Basic questions we ask in all custody disputes include the following. Are there any custodial orders from other jurisdictions? Where has the child resided for the last 6 months? Has the child been outside the state of Nevada in the last 6 months? If so, why? Who lives with the child? If there are already custody orders, regardless of what state made them, does the child or one of the parents continue to reside in that state? The answers to these questions help us assess if the state of Nevada is the proper place to establish or modify a custodial order. If a child moved to Nevada or moved from Nevada close to a 6-month date, then of particular importance is the exact date of the arrival or move date and any proof that a parent may have regarding that date. Even if a child has not been in the state of Nevada for 6 months, NRS 125A.335 permits the court in the state of Nevada to exercise emergency jurisdiction and to make temporary orders if the child is located in the state of Nevada. There are specific factual elements that must be met for the court to take the action, but it can happen in limited situations. Under the right set of circumstances, those temporary orders can become permanent orders. Under the UCJIA, Nevada judges are encouraged to schedule a teleconference with judges in other jurisdictions when there is a dispute regarding which state has the authority to rule on custodial issues. Regularly, attorneys appear at UCJIA teleconferences and are permitted to argue a parent's position regarding custody.
There is so much more to cover in this case. What you have seen here doesn't even begin to scratch the surface. We will be covering this in more depth in the days and weeks to come. For now, I will leave you with our last piece of evidence for this video.
To do, Mr. Henty.
Judge, under the Sixth Amendment, I'm allowed to represent myself.
Well, let's not talk about whether
okay,
you.
No,
hold on. Let's not talk about whether the court should exercise its discretion or make a finding. Is that what you want to do? You want to represent yourself?
Correct, sir.
Yes or no?
Yes.
All right. I'm not taking that up now. How come? I don't have time for this. It wasn't set for this. We're on the eve of trial. I have other things to do. However, I will take this matter up Monday morning at 8:45 a.m. I've already set a hearing on the motion to quash. We'll take this matter up first. And then if you end up representing yourself, we're going to go right into the motion to quash with you being self-represented. If the request is denied, we're going to go right into motion to quash. Mr. Silverberg remains your counsel.
Do you have a bond to sit on the bench, Judge?
Pardon me?
Do you have a bond to sit on the bench?
So that's enough, Mr. Henty. You can have a seat.
8:45
Monday morning, Mr. Henty.
I understand that, Judge. This court has forced counsel upon me, and in violation of Rule 1.16 and the Sixth Amendment.
Okay, Mr. Henty, thank you. I understand your position. You're wrong. You're wrong. You're wrong in many different ways. You're also being disrespectful to the court.
I'll sit down. Corruption.
State of Nevada Executive Department Certificate of Election bears the Great Seal of the State of Nevada. This is to certify that at a general election held in the state of Nevada on the 3rd day of November 2020, Barry Lewis Breslow was duly elected to the office of Judge of the 2nd Judicial District of the state of Nevada, Department 8, for a term of 6 years from and after the 4th day of January 2021. Now, therefore, I, Steve Sisolak, Governor of the State of Nevada, by the authority vested in me by the Constitution and laws thereof, do hereby commission him, the said Barry Lewis Breslow, as a judge of the 2nd Judicial District of the State of Nevada, Department 8, and authorize him to discharge the duties of said office according to law, and to hold and enjoy the same, together with all powers, privileges, and emoluments thereunto appertaining. In testimony thereof, I have hereunto set my hand and caused the Great Seal of the State of Nevada to be affixed on this 30th day of December, 2020. And it is signed with a squiggly line that I suppose is supposed to be Steve Sisolak, Governor of the State of Nevada, and by the Secretary of the
Former
State of
governor
Nevada,
now, actually, but yeah.
Yeah, former Governor of the State of Nevada, Steve Sisolak, and it is signed with a squiggly line that I suppose is supposed to be the former Governor of the State of Nevada, Steve Sisolak, and by the Secretary of the State of Nevada, Barbara K. Sagowski. I, Barry Lewis Breslow, do solemnly swear that I will support, protect, and defend the Constitution and government of the United States and the Constitution and government of the State of Nevada against all enemies, whether domestic or foreign, and that I will bear true faith, allegiance, and loyalty to the same, any ordinance, resolution, or law of any state notwithstanding, and that I will well and faithfully perform all the duties of the office of Judge of the 2nd Judicial District of the State of Nevada, Department 8, on which I'm about to enter. So help me God. Barry Lewis Breslow. Subscribed and sworn to before me this 4th day of January AD 2021. And there's an illegible signature, which it's difficult to make out exactly who that would be, but it's not the Chief Justice of the Supreme Court that I guess ordinarily signs these documents, because that's scribbled out and it says Chief Judge 2nd Judicial Court.
More updates and evidence on this case soon. Thank you for watching.
Okay, folks, now we're going to get into the article, and I'm going to, excuse me, I'm going to go through and read this verbally for everybody as we get through the article, and I think everybody will appreciate and enjoy how I tie this all together, because it's monumentally historic. We're making history right now, folks, so you're going to love this. So
All right.
In this forensic analysis, I will be presenting an evidentiary, oh no, I already went through that, sorry. Here we go. Before anything else, it is important that you, the reader, understand how we conduct our reporting standards when doing a case analysis such as this one. Our fact-checking policy is as follows. We will always provide a clear chain of custody, user-verifiable fact-checking trail of our sources to cross-reference and verify the information we provide. In most cases, we will provide direct source links, along with the source domain, as well as clickable seek time codes if there is a corresponding video that goes with the article, along with supporting sources in some cases to establish or verify information beyond a reasonable doubt. And you can click that and you can see what beyond a reasonable doubt means according to cornell.edu or law.cornell.edu for your convenience. In the event that we are unable to direct link to a direct source via hyperlink because of unforeseen restrictions such as sealed documents, etc., we will attempt to find supporting sources to corroborate the facts we are trying to verify. We follow a standard in our fact-checking process whereby we cross-reference multiple independent sources. We do not use other fact-checking sites as sources for our information, as this is completely ineffective and contradictory to the proper investigative practices employed when establishing the burden of proof in accordance with U.S. Common Court law precedent, which is the standard by which we judge our fact-checking process. We will also attempt to establish a timeline and clear chain of custody of our sources for any given article or story. And that is per our Terms of Service page, Code of Conduct section. And you can do that for yourself. Just click the screenshot link, it'll take you right to it. If you want to know more, you can read our reporting standards on our Terms of Service page. One of the most important points to note in this analysis is the Nevada Judge's Oath. Now, I provided a link to it as well with the screenshot. You can also click it here. It'll take you to it as well. Easy for you to verify and see for yourself. It won't interfere with your article or where you're at in it because it opens in a new tab. So according to Nevada Revised Statute 282.020, the Nevada Judge's Oath is meant to ensure that judges adhere to the Nevada State Constitution and the United States Constitution. When a judge does not uphold their oath, it can be not only detrimental to public trust in the legal system, but also breeds more corruption, especially when there is no accountability. And as the saying goes, absolute power corrupts absolutely. And we can now clearly, we can all now clearly see the reason for the origin of this phrase, especially in light of all that has been uncovered in the last 3 years post CD19 lockdown. For our next source in this Who Framed Roger Rabbit forensic timeline analysis, we have the application for a TPO, for temporary protective order, filed by Roger Hillygus against his sister Robin Renwick, dated December 24th, 2013. I've taken the liberty, folks, of embedding the actual document into the page right here. I've also included screenshot versions and done my little synopsis and analysis for you guys in my own words, and a few block quotes as well from some of these documents. As you will see in the highlighted screenshots, Roger Hillygus claims on his TPO application are perfectly valid, and I can't imagine not having exhausted every possible other option, legally speaking. Roger did everything by the book as far as I can see from the discovery provided for this timeline. As the rest of this story comes into focus, by the end of this article, will have the following points to take away from this analysis. We will have established the means. Hold on. We will have established the motive. Oops. Hold up. There we go. Sorry, folks. It took me back to the top of there. There we go. We will have established the. Let's start that again. We will have established the means. We will have established the motive. We will have established the financial incentive. All of the above beyond a reasonable doubt. You can click that and go check it out in full screen for yourself. And you can also click at the bottom where there's the description for each, or the caption for each image. You can click on that, and that will take you to the actual document and the page where that specific source is in that document. It'll take you right to it. See, as you can see up here, it'll take you right to page 4. So I made it easy for everybody, folks. So all you got to do is click them. Just based on the claims made in the TPO application by Roger, I imagine that most rational, level-headed individuals would have done the same in his position. And here's the second page of his statements for that application. All right. An important thing to note here is the TPO application claim dated December.
He's aggressive.
Oops, hold on. I'm not ready for that yet. Sorry, I have this set to autoplay when you scroll, so. Is the application claim dated December 23rd. This claim is what Robin Renwick tries to spin in the Stone Valley Care Facility body cam footage by stating the following to the responding officer. He's aggressive. Did you know the sheriffs had to remove him with a SWAT team from the house? And the sheriffs wouldn't do it without a court order because he threatened that he had guns. He does have guns. Freaking evil, freaking conniving woman, man. I swear to God, what is wrong with some people? So evil.
Do you know that the sheriffs had to remove him with the SWAT team from this house?
From your mom's house?
And the sheriffs wouldn't do it without a court order because he threatened that he had guns. And he does have guns. So if they go out to Dayton, they need to be aware what they could possibly be walking into.
And we'll let them know.
Up next in our timeline is the objection to master's recommendation, extended protection order against domestic violence, and request for de novo hearing. This document is where the narrative begins to do a complete 180 turn. As you will see in the arguments made by attorney Todd Tervinen against Roger's claims from the objection to master's recommendation, extended protection order against domestic violence, and request for de novo hearing filing. As we see, we've embedded it there for your convenience. Below is a bullet point list of some of the arguments against Roger's claims. 2. Specific factual objection. The applicant, Roger Hillygus, the named successor trustee under the Hillygus Family Trust, without legal right, and this is ironic considering he's the successor, folks. Without legal right, he moved himself into his parents' residence at 2685 Nob Hill Drive, Reno, Nevada, and assumed the role of successor trustee in violation of the terms of the trust agreement and over the objection of his father, Gene Hillygus. It was the body cam footage, Allie, the Stone Valley body cam footage.
And now,
of his father.
can I ask a question, or am I okay?
Yeah, you're fine. Go ahead if you want to.
Okay. So, but wasn't that the same day he went and got his mom was August 8th? But she's saying that previously, it's like she was talking about previously, but so he had to be removed. He was removed from the mom's house by SWAT team two times. Like,
yeah, she's exaggerating there. Obviously, I mean, I don't think the SWAT team was involved. I mean, I know that Roger said he got evicted because they forced that because of all the things that's going on.
I actually have the paperwork on that.
Oh, awesome.
Yeah, it's in the drive I just gave you guys access to. But it's in there. It does say, I do think that they actually did send out the SWAT team, but that I don't doubt that. They use excessive force all the time in Marshall County. So, you know, they gear up in a gung ho to do that all the time.
The point I was getting at is establishing a narrative as far as Robin's narrative goes.
Yeah, understood.
Yeah.
I just picked up on that the SWAT team was involved 2 times. I thought.
Yeah. No, I just it was like it's funny how you can pick out if you listen carefully, right?
Mm-hmm. Yeah. Thank you.
Mm-hmm. All right, let's continue. Because all this will be kind of revealed when we go through the rest of the documents as well, folks. So just hang tight. Gene Hillygus, over the objection of his father, Gene Hillygus. Roger Hillygus then began self-serving conduct in order to enhance his own standard of living at the expense of his parents, particularly his father. In addition, he effectively removed his father, Gene Hillygus, from his own residence. This is more fully outlined in a letter from Stephen C. Moss, Esquire, dated January 8, 2014, which is attached here too as Exhibit 1. And then this is a block quote from their document from Todd Tervinen's filing, folks. So just keep that in mind. These are not my words. These are just quotes. December 2nd, 2013, when the 9/11 call is placed to the Washoe County Sheriff's Office, Gene Hillygus was with the applicant and authorized the same. Moreover, this is not harassment. Roger Hillygus was breaching fiduciary duty and converting the personal property of the trustees, Gene Hillygus and Sue Hillygus, and transferring it to his own personal residence in Dayton, Nevada. As you will soon discover, what is unthinkable is the fact that they are completely ignoring all of Roger's attempts to get his due process. An important thing to point out that is missing from the embedded PDF above, objection to master's recommendation, extended protection order against domestic violence, and request for de novo hearing is Exhibit 1. The alleged letter from Steve Moss. Shouldn't it be included as part of the PDF filing? How come they did not include it in Roger's copy of this filing in the court by Todd Ravina? I find this highly questionable and suspicious. This is just one of the many ways and tactics I have seen these bad court actors deprive individuals of their due process and use in order to case fix. In every regard, this case is by far one of the most obvious in the context of being able to see the difference in contrast as it pertains to how obvious it is. Our next source is order after hearing regarding Roger's TPO application. It is important to point out the date in this order after hearing regarding Roger's TPO application, which is shown as filed January 15th, 2014 at 8:50 a.m. This date is relevant as it pertains to our next source in the timeline. Roger's filing of Exhibit 1 for the Hillygus Family Trust restated, dated August 17th, 1993, filed January 14th, 2014. This fact is relevant because it effectively demonstrates, even if only circumstantially, that Roger knew he was being railroaded. As such, one would expect his next move to be a legal filing pertaining to his legitimate and lawful role as successor trustee. This is so that it is on the official court record. Claims, filings, and facts put on the court record in court is the best way to ensure that you have a legal chain of custody in regards to evidence which can be used in future court hearings. This is simply because the court record is what they will go by when looking at each side's claims. That is assuming, of course, that the court and court actors are actually impartial, fair, and not corrupt. And here is that filing, and you can see for yourself they dismissed it. And we have a screenshot of it as well. Roger, as you will clearly see in the highlighted screenshot below of the order after hearing filing, they dismissed Roger's TPO claim. It is hereby ordered that the order for protection against domestic violence originally issued on December 24th, 2013 in the above entitled case is hereby dismissed. And you can see for yourself that's exactly what they did. They ignored him. It is important to point out that if Roger's TPO against Robin Reynolds was maintained, there would have been no legal basis for the court to be able to revoke trust. Which leads to our next source, which is listed as Exhibit number 1 for case PR 14-00025, which is for probate court. Admin note: you can tell which court filing is for based on the case number, i.e., the first two letters in the case number usually indicate the court in which the case is being heard. In this case, PR stands for probate. The first two numbers after the letter designation indicate the year in which the case was filed. In this case, the 14 in PR 14-00025 stands for the year the case was filed, which was 2014. The 5-digit numbers following the hyphen indicate the actual case number. Exhibit number 1, case PR 14-00025, the Hillygus Family Trust restated, dated August 17th, 1993, is the next source referenced in our forensic timeline analysis. This filing and the related filings hereafter related to case PR 14-00025 and the Hillygus Family Trust, in addition to all the evidence presented hereafter in the timeline, will clearly demonstrate beyond a reasonable doubt the following facts. That there is clear and convincing evidence of fraud upon the court as it pertains to case fixing. And you can see what that is here, folks, for yourself. I have a link to a really enlightening document on judicial misconduct from uscourts.gov. That there is clear and convincing evidence that the court committed fraud in order to seize the assets, trust, and trusts of the Hillygus Family Trust. 3, that there is clear and convincing evidence of RICO, racketeer, influence, and corrupt organizations by the court, including, but not limited to, judges, lawyers, both private and court appointed, Stone Valley Care Facility personnel, as well as many others in positions of authority. Now, this Exhibit 1 is the original trust statement from 2011. The one that has Roger as the successor trustee. That's their first exhibit. And so the next piece of exculpatory evidence in our forensic timeline analysis is Exhibit 2, First Amendment to the Hillygus Family Trust. Oh, actually, I think this is actually their filing, my mistake. This is the other side's filing, I believe. Exhibit 2, the First Amendment to the Hillygus Family Trust, restated, dated August 17th, 1993. It should be noted that the date of the signing on this amendment up to the trust is the 3rd day of January 2014. This is important to establish as it shows clear intent relative to the timing of the filings in the TPO, temporary protective order, application and dismissal therein in case number FB, which stands for Family Violence Court. That's basically domestic violence court. 13-04189 in regards to what these bad court actors are actually doing. And you can see here they appoint Adam Clark as successor trustee. This First Amendment of the Hillygus Family Trust is also the justification that Steve Moss uses to unlawfully and unethically hijack the Hillygus Family Trust. According to page 3, paragraph 2 of this First Amendment to the Hillygus Family Trust, which is for Exhibit 2, case PR 14-00025, all terms of the Hillygus Family Trust, restated dated August 17, 1993, shall remain the same, except for the following. 1. The existing terms of section 9.1.2 are deleted in their entirety and replaced with the following. 9.1.2. If either H. Eugene Hillygus or Susan L. Hillygus shall die or shall for any reason fail to qualify or cease to act as trustee, the remaining named individual shall act as trustee on the death of both settlers or upon the incapacity of both settlers or the surviving settler. Adam Clark is appointed as successor trustee. From page 3, paragraph 2 of the First Amendment to the Hillygus Family Trust, which is Exhibit 2 for case PR 14-00025 on this filing. And you can see it yourself, highlighted there, boom, it's right there, easy peasy. Next in our list of sources for our forensic timeline analysis, an article, Who Framed Roger Rabbit? The Roger Hillygus case is a joinder petition regarding administration of revocable trust, case number PR 14-00025. One thing I think is important to point out is the inconsistency between the dates on the cover page and the certificate of service page. As you can clearly see pointed out on the screenshot of the cover page and the certificate of service page of the joinder to petition regarding administration of a revocable trust below, respectively, we can see the following. Page 1, cover page of the joinder to petition regarding the administration of a revocable trust is dated the 11th day of June 2014. Page 2, certificate of service of the joinder to petition regarding administration of a revocable trust is dated the 11th day of June 2013. And we can see that for yourself, and I point out the inconsistency with the dates here. Make it easy for everybody to see for themselves. The little wordplay and legal loopholes they like to use, folks. But you'll see some more of these here too in subsequent filings, and it's one of the tactics they use to get around accountability. Was this a mere clerical error by a staffer of law office of Todd L. Trevinian, or was this a concerted effort to use legal loopholes and wordplay to commit fraud upon the court? While an interesting curiosity by itself, it is hard to discern intent based on this mere one observation alone. We need more, which brings us to our next piece of evidence. This is where things begin to get interesting, so pay close attention. Next, we have the objection to petition regarding administration of revocable trust, case number PR 14-00025, filed by Woodburn and Wedge, attorney for Roger Hillygus. According to this objection, starting on page 4, under section 4, write, amend, or revoke successor and I think SIC, it stands for something to do with the successor trustee, basically. After Gene moved out of the marital residence, Roger and his wife Debbie moved in so that they could care for Sue. Sue prefers to live in her home, and it has been suggested that maintaining her routine and having stability is beneficial to her. Roger and Debbie selfishly left their home in Dayton to move to Reno to assist Sue. Roger had been commuting from Dayton, Nevada on a regular basis for several months to provide care and assistance to his parents. Rather than be thankful for this family support of Sue, Robin and Jean began a campaign against Roger and Debbie, which eventually resulted in Roger and Debbie being evicted from the marital residence. Sue was then left alone in the home by Jean and Robin, and ultimately had a breakdown and ended up in the hospital after Roger found her lying on the floor of the residence. Throughout this period, Mr. Moss repeatedly advocated Jean's position that Roger could not live in the home to care for Sue, that Sue should leave the marital residence, and that the home should be sold. Therefore, notwithstanding Mr. Moss' original representation of both Jean and Sue, since mid-December 2013, Mr. Moss has undertaken to represent Jean alone without regard to Sue's interests or desires. Because of his prior representation of both Jean and Sue, Mr. Moss had an ethical duty to withdraw from representing either of them at the moment Sue's and Jean's interests diverged. Mr. Moss has never obtained, or to the best of Roger's information and belief, even attempted to obtain a signed waiver from Sue or her counsel, which would permit him to continue to represent Jean in matters that are adverse to Sue's interests. Mr. Moss was reminded of his duty to withdraw by the undersigned in mid-January 2014 and again in February of 2014. Once both Jean and Sue had been deemed incompetent by two doctors, Roger assumed his duties as trustee. See notice confirming appointment of successor trustee and attached hereto exhibit. Jean and Roger's relationship improved over the last few months, and Jean has decided that Roger could be confirmed as the successor trustee. However, Mr. Moss, without his client's authority, still persists in his frivolous attempts to confirm the amendment, with the result that the Hillygus family's limited resources continue to be needlessly squandered on legal fees. Roger respectfully requests that this court deny the petition. Roger and his wife, Debbie, have tirelessly cared for Sue. Roger is committed to responsibly serving as successor trustee of the trust. And here's the objection to petition regarding administration of revocable trust, case number PR 14-00025, page 4, under section 4, right, amend or revoke, paragraph 2. And you can see that there for yourself. And this one as well. And this one as well. Take note of the mention of Exhibit 2, notice confirming appointment of successor trustee, referenced in the objection to petition regarding administration of revocable trust. This exhibit is what proves beyond a reasonable doubt that Stephen Moss colluded and conspired with other court actors, i.e. Todd Provinen, Robin Renwick, and others to unlawfully steal the Hillygus family trust from its rightful successor, Roger Hillygus. We will get into that shortly after we briefly touch on Exhibit 1 below. Following that, we have Exhibit 1 from the objection to petition regarding administration of revocable trust. This exhibit shows the original Hillygus family trust restated, dated August 17, 1993, signed and dated August 24, 2011. And it was filed 6/18/2014 for this exhibit. Objection to petition regarding administration of revocable trust. Exhibit 2 is our next source referenced in the timeline. This is also the exhibit where there is clear and convincing evidence of fraud upon the court by attorney Steve Moss, whom referred Eugene Hillygus to a competency evaluation on April 25, 2014, in which Robin Renwick appointed him or accompanied him to. This competency evaluation was performed by Deborah Fredericks on the following 3 dates: 4/28, 4/29, and 4/30/2014, who requested and referred to Deborah Fredericks by Stephen Moss. Prior to that, almost a full year earlier, on 5/1/2013, Eugene Hillygus was seen by a doctor and diagnosed with dementia. On his follow-up evaluation, dated December 12, 2013, it was further determined that the dementia was vascular in nature. You may view the entire exhibit for yourself below as an embedded PDF. You may also view the screenshots of the relevant portions of this exhibit below the embedded PDF for your convenience. I have taken the liberty of putting a red circle around the most relevant statements from Exhibit 2 that refute Robin Reynolds' claim and the claims of Deborah Fredericks that Roger was exploiting his father. Okay. This is from Dr. Ken Elliott's evaluation when he was first diagnosed with dementia, and it says here in his initial statement, the family noticed that he is repeating himself, social inappropriateness, like not considering other people, personal space, hugging everybody, and at one point he had an obsession with the form of internet cards, which involved check writing. Now this is relevant because of what Robin's claim is going to be a year later, and Steve Moss's claim. But we can show that they twisted the truth, in fact. As we can see in the screenshot above, the reason for the visit to Ken Elliott, MD, was new patient, which is an acronym for new patient, which is PT, was the acronym there, and possible dementia. The encounter or exam occurred on May 1st, 2013. We can also see this in this screenshot, a mention of Eugene Hillygus having at one point an obsession with some form of internet cards, which involved check writing. Below, we have the screenshot from the report of the diagnosis that was determined from this initial visit. Dementia, primary, 294.20 is the code for that, folks, the medical code, I believe. And you can also check out the original, in the original PDF exhibit. It takes you right to it. So, as we can see from above, the diagnosis is dementia, 294.20, primary. This establishes that Jean had dementia at the very least as early as 5/1/2013, which is May 1st, 2013. The next screenshot is from the follow-up visit dated December 12th, 2013. It shows the reason for the visit and the encounter date. Medication problem. And there we go, December 12th, 2013. As we can see above, the reason for the follow-up visit is listed as a medication problem. The date of the encounter or exam occurred on December 12th, 2013. It also mentions in the comments that Roger brought in a letter from their attorney, Steve Moss, indicating a need for a letter supporting the fact that with his dementia, Eugene Hillygus cannot take care of his own financial and legal affairs. Admin note. That letter was provided by Kent Elliott 1 month later on January 12th, 2014. This letter will be coming up in the following the next screenshot. Next, we have the diagnosis screenshot from the follow-up visit on December 12th, 2013. Diagnosis, dementia vascular, medical code 290.40. And then you can see that for yourself. There you go. You can also see it in the original embedded PDF if you want. If you're so inclined, you can actually click on this right here, and it will take you to the actual portion or page that is in the actual PDF for your convenience, folks. As we can clearly see from above, the diagnosis was updated to dementia, 290.40, medical code, vascular. Next, we have the actual physician's certificate with needs assessment. It should be noted that Kent Elliott, MD, in his certificate with needs assessment letter to Stephen Moss clearly illustrates the following facts. On page 1 of the physician's certificate with needs assessment, that Kent Elliott, MD, is a physician licensed to practice in the state of Nevada. That Eugene Hillygus has been medically diagnosed with vascular dementia. The physician's certificate with needs assessment on page 2 establishes 1. That Eugene Hillygus was not at immediate risk or need. 2. That Eugene Hillygus had not been subject to abuse, neglect, or exploitation. This directly contradicts the narrative perpetrated by Robin Renwick, Stephen Moss, and other bad court actors. Let's just go full screen so everybody can see just how blatant it is. I certify that this patient is unable to respond, check all that apply to a substantial risk of an immediate risk of physical harm, to an immediate need for medical attention, to a substantial and immediate risk of financial loss. Describe immediate risk or need. No current immediate risk. It should be noted that this statement by Dr. Kent Elliott clearly illustrates that there was no immediate risk. Does the patient present a danger to himself or others? Yes. Does the patient present a danger to others? Why or why not? Yes. Danger, risk of wandering, getting lost, etc., stuff like that, accident from driving. Has the patient been subjected to abuse, neglect, or exploitation? We check no. It should be noted that this proves, according to Dr. Kent Elliott's own determination, that Eugene Hillygus had not been subject to abuse, neglect, or exploitation. This is contrary to Robin Renwick's claims that Roger was exploiting his father. Okay? That's important, folks. Now, on page 3 of this physician certificate with needs assessment, we have, it is established, 1, that Eugene Hillygus was unable to manage his own physical or legal affairs and was in need of a guardian. You can see that clearly there. You can also click it and open it up in a new tab for your convenience. It says, does the patient need a guardian? Yes. Unable to manage own physical and legal affairs. This part in section 2 demonstrates that Eugene Hillygus was in need of a guardian to manage his affairs. Why was this ignored by Mr. Moss? So now the question is, why did Stephen Moss ignore the fact that Eugene Hillygus needed a guardian for so long? As you are about to see in the next set of screenshots, you will understand exactly why Stephen Moss ignored the fact that Eugene was in need of a guardian for so long. And I would argue, based on the evidence you're about to see hereafter, that the reason he waited so long was because he could not proceed with that step until Mr. Moss and all co-conspirators had legal authority of the trust, which meant they had to get a second medical opinion that worked in their favor, at which point the court would be able to assume legal authority over the trust. And finally, on page 6 of the physician's certificate, we can see, with the needs assessment, we can clearly see the date is 12th of January 2014, and we can clearly see Dr. Kent Elliott's signature. 12th January 2014, okay, that's pretty obvious. That too is nowhere near 4, obviously. That's a 12, clearly. January, and then 2014. The date here says 12th of January 2014. Pay close attention to Deborah Frederick's competency evaluation on page 2, which is coming up shortly in our timeline. There are some inconsistencies I will point out when we get to that document in reference to Dr. Kent Elliott's physician certificate with needs assessment. The following screenshot is the letter from Stephen Moss requesting a competency evaluation by Deborah Frederick. There are a few statements in Moss's request letter that are relevant to establishing his intent regarding in regards to needing a second medical opinion that worked in his and his co-conspirators' favor. Above, we have 3 data points to demonstrate Stephen Moss's intent. Dear Dr. Fredericks, I represent H. Eugene Hillygus. There is a matter pending in the probate department of the local district court, which requires a competency evaluation of Gene and his wife Sue Hillygus. Some of the issues that require the evaluation of a medical professional are, and then she goes on. This clearly demonstrates Mr. Moss's intent to get a second opinion for the medical competency evaluation that worked in his favor, so he could proceed in the probate department of the local district court to take legal authority over the Hillygus family trust. The second data point is based on the second bulletin point in Mr. Moss's request for a competency evaluation by Deborah Fredericks. Is Gene or Sue Hillygus competent to make decisions about managing their personal financial affairs, including changing successor trustees and amending distribution of their estate? This second bullet point in Mr. Moss's request for a competency evaluation clearly demonstrates his intent to change the successor trustees, in addition to amending distribution of their estate. Finally, the third data point clearly shows Stephen Moss's signature on this document. This clearly establishes that it is indeed Stephen C. Moss Esquire based on his signature here and its comparison to previous signatures on other court documents. Moving on to the competency evaluation administered by Deborah Fredericks. This next piece of evidence is critical to understanding how the courts are conspiring and case fixing by ignoring evidence that doesn't work in their favor and seeking out evidence that does, in spite of the fact that their claims don't hold water. The document you are about to see screenshots from clearly demonstrates this, and even admits that Robin Renwick told Deborah Fredericks that she thought Eugene Hillygus was being manipulated by Roger. That is hearsay, and I would even argue we can clearly establish intent by Robin Renwick to manipulate Eugene Hillygus due to her recognition of his incompetency to manage his fiscal and legal affairs and the timing of the second opinion before they proceeded. Furthermore, it has been established through Roger's own testimony that there was resentment and spitefulness on behalf of Robin Renwick because of the California trip, which, according to Roger, Robin felt alienated because she was not included in this trip. This establishes a clear motive for Robin's actions in regard to manipulating her father in his now incompetent state. You can see that for yourself. According to the cover page screenshot from above, we can see Deborah Fredericks' response to Steve Moss's request for a competency evaluation. Thank you for referring Mr. Hillygus for competency evaluation. As you know, this is an 80-year-old who is trustee of the Hillygus Family Trust. Mr. Hillygus' wife has advanced Alzheimer's disease. He is currently living at the villas, while his wife lives with their son and daughter-in-law in Dayton, Nevada. There is some concern over possible financial exploitation by the designated first successor and Mr. and Mrs. Hillygus' son, Roger. The principal question put forth for this competency evaluation is whether Mr. Hillygus is able to function as sole trustee. Mr. Hillygus was accompanied by his daughter, Robin Renwick, on 3 occasions, and she has on her own statement, it says 4/2/2014, but I believe that's a typo, and I'm going to get into that shortly. 4/29/2014, and we're going to give you the actual date that it was on, and 4/30/2014. Mr. Hillygus, along with his daughter, were interviewed during our first visit. Then he returned for a cognitive testing and further interview on the second and third visits. The majority of testing was conducted on April 29th, 2014. When he returned on April 30th, 2014 to complete testing, it was reported that he had visited urgent care at AM due to an onset of shingles overnight. Due to this event and the fact that he did not sleep well the night before, secondary to shingles pain, only a few tests were administered. However, during the first testing session, he was not experiencing any complaints of pain or discomfort. Something important to note here in this second paragraph is the dates for the competency evaluation. In Deborah Frederick's statement, there is a typo on what appears to be the initial visit, which according to Deborah Frederick's own statement was the day the interview was conducted. The typo is noticeable as 4/2/2014, which is obviously inconsistent with the date of Mr. Moss's request for a competency evaluation, which was dated 4/25/2014. Because the date of 4/25/2014 fell on a Friday, we can reasonably assume that the correct date of the interview fell on the following Monday, which would have been 4/28/2014, based on the other two dates mentioned by Deborah Frederick. See figure 1 below. I took the liberty of using color codes and corresponding letter indicators for each date in question, starting with the date of Mr. Moss's request letter, 1A in green, followed by the listed dates as listed by Deborah Frederick in her statement. 4/2/2014, 1 is 1B, 4/29/2014 is 1D, 4/30/2014 is 1E in blue, and ending with the actual date of the interview, which we reasoned through logic and common sense had to be the most likely one, which is 4/28/2014, 1C in yellow. As you can see here, you can open that as well and check it out for yourselves. It is unclear whether the typo in the interview date was intentional or not. However, isn't it coincidental that the interview date would be the date that the typo was made on in her statement? Here's the next inconsistency with another date. At the start of page 2, we have Deborah Frederick's statement from her competency evaluation. Primary care physician is Dr. Elliott, MD. Review of Dr. Elliott's notes for 1/14/2011, which doesn't make any sense. I could see her mistaking the 2014 date on his document for 2011, but I don't see how she got 14 from 1/2, which just doesn't add up to me, especially the way he wrote it. Indicates a history of prostate cancer, hypertension, hyperlipidemia, gout, hip replacement, and vascular dementia. Current medications include Namenda, and the 2011 note by Dr. Elliott reports albuterol, Cialis, amiprozole, levothyroxine, Avalade, allopurinol, Aricept, and Verapamil. Now, I want to point out that this one right here is how we know that that's the document that she's referring to, and that's not some other document. And we also know that this is referring to that because he was a new patient in 2013 to this doctor when he first got his diagnosis. So I want to point that out. But yeah, so it should actually be, I don't know why she made this big of a fuck up. I mean, nobody in the medical field should be making that big of a fuck up unless they're just completely incompetent or doing it locally. So I want to point that out. The first thing I would like to point out regarding this first statement on page 2 by Deborah Fredericks in her competency evaluation is the fact that she again incorrectly referenced the actual date of Dr. Elliott's physician certificate with needs assessment, which was dated as 12th of January 2014. Deborah Fredericks incorrectly referenced the date of this assessment in her statement as 1/14/2011. I find it hard to believe that this could be a simple misreading of the date on Dr. Elliott's assessment due to the fact of the format in which he wrote the date on his assessment. At this point, I think it is safe to say that Deborah Fredericks was aware that she was committing fraud when she wrote this competency evaluation. Based on the inconsistencies with the dates, as well as the fact that she perseverates from correctly spelling Mr. Hillygus' name to misspelling it, then correctly spelling it again several times in her competency evaluation. To be completely honest, in my opinion, I think Deborah Fredericks is the one who is the need of the competency evaluation. I know, the irony is irresistible. On page 2 of Deborah Frederick's competency evaluation, we have our second statement of relevance, which states the following. The financial situation is at question since both Mr. Hillygus or Miss Hillygus was declared incompetent to function as co-trustee, and Roger is named as first successor trustee. Basically, in layman's terms, they're saying Roger's a problem for them and they need to get him out of the way. Is basically what they're saying between the lines, folks. Mr. Hillygus reported that he is currently sole trustee and cannot recall whom was named as first successor trustee. And then they bring this up like 3 different times, which is odd. But I'm going to tie it in. One of the main things I want to point out in this statement is the misspelling of the Hillygus last name. In the statement above, it clearly shows that Hillygus was spelled with a second I instead of a Y. Spelled Hillygus, as opposed to Hillygus. It is entirely possible that it was an honest typo. However, in this case, in combination with the inconsistencies with the dates and several other factors, I would argue that this is evidence that she knew that what she was doing was fraudulent, which makes her a co-conspirator. However, what is important to note in this statement is the statement by Deborah Frederick, which is the first sentence, and states, the financial situation is at question since both Mrs. Hillygus was declared incompetent to function as co-trustee and Roger is named as first successor trustee. This clearly shows that Deborah Frederick knew that Roger Hillygus was named as first successor trustee. It also demonstrates that the potential motive for the second medical opinion and competency evaluation was the financial situation. The second statement by Deborah Frederick, which is the last sentence highlighted in the screenshot, states the following. Mr. Hillygus reported that he is currently sole trustee and cannot recall whom was named as first successor trustee. This second statement clearly demonstrates that Deborah Frederick knew that Eugene Hillygus's mental faculties were not all there, as according to her statement, Mr. Hillygus reported that he is currently sole trustee and cannot recall whom was named as first successor trustee. This presented the perfect opportunity for Stephen Moss and Robin Renwick and their co-conspirators to take advantage of this favorable competency evaluation based on the timing of the second opinion by Deborah Frederick and the subsequent filings hereafter for case PR 14-00025. On page 3 of Deborah Frederick's competency evaluation, we have the following statement. He reports that his investment portfolio has not been depleted and valued at over $300,000. He understands that he can no longer manage his financial affairs, but is adamant that Roger not be named as trustee. He believes Roger has some brain damage from the accident that caused his disability, in addition to having exploited money that Mr. Hillygus believed was to be exclusively for the care of his wife. He reports that he trusts his daughter, Robin, and granddaughter in making financial and personal decisions on his behalf. The main point I would like to make regarding this statement is that if Roger was truly brain damaged from the accident, then why was he deemed competent to represent himself pro se in this current prosecutorial criminal trial being perpetrated upon him?
Everybody there?
Yeah, we're here.
So I might as well let the cat out of the bag because it's already allowed in the bag. Last was it Friday? Friday. I got two text messages from Ian, pretty much almost back to back. Now, since the son of a bitch never really reaches out and connects with me in communication, I thought something was up, and it was. He said that based on what happened on the 7th and 8th, that he was going to file a motion to dismiss for the allegations of prosecutorial misconduct and malicious prosecution and wasteful expenditure of taxpayers' money, time, and resources. That's been
wow, that's great news, right, Stu?
Well,
I mean,
I'm gonna tell you something. It is, but
you don't have any faith in it.
Well, after 4.5 years, Anne Marie, I don't have too much faith in anything anymore. You know what I'm saying?
Understandable. Yep.
The proof's in the pudding. He said he was going to get it filed by this afternoon. However, as things have transpired throughout the course of the day, I reached out to him and I finally got a hold of him. And I checked my emails. Well, guess who decides to relent and put in the needed and required information in the plea agreement? So,
of course.
Oh yeah, of course, because it's a fucking game.
Funny.
It's a fucking game, and I'm done playing games. So
yeah,
it is a game to them.
Yeah, I think this is a ploy all along. I think they were going to see if we were going to bite on it, and since we didn't, and we reacted to it as we did, I think they said, well, I guess we should put it in there now, shouldn't we, Amos? Sure thing, Chris. We'll put it in there now. Is that your order? That's my order. I'm pretty much sure that's the way the conversation went. But since I'm getting to the point where I'm done playing games with everybody and anybody in this particular situation. Yeah, my statement to Ian, and I just sent it out in an email, say, okay, here's the deal. I'm not agreeing to anything until I see your motion to dismiss based on your whatever you're putting in there, as well as some of the 7 bullet points I sent to you yesterday, which includes a lot of stuff that needs to be put. Now, if he doesn't want to put that in there, and I said, okay, well, we got new rules now. I'm pleading no contest to, if they wanted to take it, to a gross misdemeanor, no felony. I'm not pleading guilty to any felony. Sorry, no contest is basically a guilty plea. We all know that. I'm going to plead no contest. If you don't, well, guess what, Mr. Stagey, Mr. Hicks, guess what? We get some other things cooking in the kettle, and it ain't your favorite kind of stew, if you get my drift. So,
good.
I'm done. You know, I want Roger out, but you know, they're still playing games.
Stuart.
Yeah, go ahead.
You know we're live.
Yeah, I know we're live.
It's all right. It's all right. That is perfect for update for live on the air.
It's an update. I don't care.
Surprise.
So I don't
Awesome.
care. I don't care. You know, if that's the case, you know, if they're that keen in on listening in and taping us and whatever their smarmy little asses do, which I hope they listen. Then they must be really worried. Because if I were them, if I were them, I would say, well, here's the deal, Mr. Hansky, Mr. Stagey, Mr. Hillygus, Stagey, I wish. We're not going to offer you anything except this is your charges you've been charged with. And we expect you to either enter a guilty plea or we're going to trial. And you'll be found guilty by a jury. Lest we forget, to everybody on this live stream, they already tried to do the grand jury. And see, the grand jury is basically a stepping stone for the prosecution, at least in the state of Nevada. I'm sure it's similar in other states, but state of Nevada is basically used by the prosecution when they don't have a strong case, and they don't. So that's what they tried to do. The mistake they made, the stupid mistake, because they are stupid. I mean, like I said, I hope they listen.
They really are. I mean,
they are
really
stupid
about this one.
They're stupid. Okay, they're insanely stupid. The mistake they made is they subpoenaed Roger, and of course, when Roger showed up and saw everybody there, and then when Stagey showed up and blew a gasket, what are you doing here? I'm supposed to be here. No, you're not. You're not supposed to be here. Blah, blah, blah. Roger holds up the subpoena. That's why I have the subpoena. And Roger said, you watch the color drain from his face because they fucked up. They fucked up. Yeah. So, you know, I think there's a lot of games going on behind the scenes because all the people know, and I'm sure everybody, whoever's listening, I just really don't give a shit at this point. They know the price tag attached to this is monumental. It's astronomical. And they know that they went way overboard with what they did. They know that they did not follow the laws as they're written, because if they had, there'd been nothing to go on. But, you know, I got a funny thing. How about the Rebecca Schultz case out of Las Vegas, Stephen? How about that one? The only thing different is Mrs. Hillygus was taken from a assisted care facility. Mr. Schultz was in his own home. Mr. Schultz was being abused by a guardian. Mrs. Hillygus was abused by unknown guardians. And Roger's a male. Susan's a female. Rebecca's a female. Mr. Schultz was a male. That's the only thing that's changed, because where did Miss Schultz take her dad? Southern California. And what did the Clark County District? Yeah. What did the Clark County District Attorney's Office bring him back? She said, when pigs fly. And did anything ever happen to her? No. And why are the rules changed for Roger and I? It's the exact same case, just changed locations, changed genders, the same thing. And it was a civil matter because they couldn't do anything. You know what they did? They held her in contempt of court in a civil case. She went, ha! Good for you. There was no warrant issued for anybody's arrest. This is a civil matter. Just like Officer Avila says in the body cam footage. It's a civil matter. No, I'm sorry. That is Sergeant Hannafin, the retired guy who's trying to hide. Yeah, it's a civil matter. We're not getting involved. Sorry, or I think Avila even says it's a civil matter, a civil court. There's nothing, and I'm like I said, I'm speaking off the cuff here. There's nothing in legal parameters that prohibited Roger from taking his mother. Show me. Show me the documents that says he is not allowed to take his mother. Show me. They don't exist, do they? You're right. They don't.
They don't.
They don't. So this is the whole situation. It's not about, it's about, we finally got these two pieces of crap and their eyes again that have been pestering us and bothering us and being a thorn in our side. Me more, obviously, than Roger, because Roger finally realized that it wasn't him, it was me. And I get it. I don't want to put the onus out there on my own self because I'm not that type of person. But after a while, people are like, well, why you do this? Why would they do this? Why would they do that? Why would they do this? I don't know. Why would they? And you know what I get all the time? God, you must have pissed some people off, huh? You think? You think? When you do the connected dots, you think?
Yeah.
Start putting, yeah. You think? Yeah. So, the situation is now I play my game. And I believe this is the game that they played all along. I believe Judge Hardy was the setup. Because if Judge Hardy, and here's the interesting thing, I want this live. Judge Hardy specifically said verbatim to us, well, gentlemen, I don't know either one of you, but I sure like to hear your side of the story because that's what I'm all about. You lying son of a bitch. You knew about Roger Hillygus because you dissolved the TPO between him and his sister.
Oh, oh, wow.
Yeah.
Wow.
You lying son of a bitch. And he tried to be real nice. He's a smooth talker. I tell you what, he could sell ice to an Eskimo. I'm serious. This guy's that good, but he's a smooth talker. But that those two things, him being on Nevada Commission on Judicial Discipline, which he failed to set forth, that would have been a immediate conflict. But the bigger one, especially when he says this, and of course, guess what, folks? It's none of that was recorded. There was no court reporter there. It was basically Roger and I and the two people that call themselves defense attorneys in one room, and the judge back and forth between. I don't even know for honesty purposes. I don't even know if Steggy was in the other room. For that matter, I don't believe a damn word that comes out of that district attorney's office or that court for that matter. So it could have been he was just going back and say, okay, we got him to do this. Now what? Now what, Chris? Now what? Could be, could not be. I don't know, guys, but I'm gonna tell you something right now. I'm changing up the rules. And if Roger wants to agree to his, well, he can. He needs to get out of jail. And that's the paramount issue here. They're holding him in jail illegally. And if Ian doesn't want to abide by what I have had to say in terms of adding these bullet points in, they Katie bar the door because Friday is going to be a barn burner. I've kind of cowed down because I've considered all the far-reaching parameters of everybody's involvement, especially Rogers and myself. But I'm sick and tired of shutting up. And if I'm going to push it up against the wall,
well, you should be.
Yeah, if I'm going to push it up against the wall, then I'm going to push it up against the wall, and I'm going to hold it against the wall because this crap is what changed from the 7th or the 8th, whenever you want to put a date on it. What changed from September 7th or 8th, where Steggy refused, wasn't considering it, flat out told Ian Silverberg, I'm not putting that language in there. I refuse to put that language. What changed between now and then? What changed?
Exactly.
The days, the weather, the temperature? No. I think it was a ploy all along. I think they were going to say, well, are they going to catch it? And if they catch it, then what do we do, Chris? Then what do we do? Well, we don't, well, we have to consider it. And they already know, I'm sure as I'm sitting here talking to you all, they already know what Ian's putting forth. Now, the other little interesting scenario here is I was told Friday that this motion to dismiss is what it's called. That includes prosecutorial misconduct, malicious persecution and prosecution, wasteful expenditures of taxpayers' time, money, and efforts. Was supposed to be done this afternoon. Now he said he's sick today. I'll take the man on his word for that because I'm not gonna rail on somebody if they're sick. But we've talked about the word coincidence, and we've talked about the word coincidence. And I firmly sit here and tell everybody on this live stream, there's no such word as coincidence, right? There's no such word as coincidence. Was it a coincidence when Building 7 collapsed after not being hit by any airplanes after two twin towers came down? Nope. Yep, no coincidence. Was it coincidence when JFK's head snapped back into the left because it was shot from an angle from the front? In small, out big. I know a little bit about big game hunting, just a little bit, just enough to get me in trouble. I don't shoot animals. People, maybe a different story. But just no coincidence. It's not a coincidence. That word does not exist. It does in verb form, but not my vocabulary, and I hope nobody else's vocabulary either. So it's just a weird thing to say, oh, wait, Amos, Yeah, he's going to put that language in there now, and I have yet to read the email, but it's apparently in one of my emails that Ian said. So my statement, and I'll get off my soapbox here. Okay, Ian. Well, there's some bullet points I set forth to you in an email. I like at least all of them, if not some of them, included in your motion to dismiss because it bears mention and is a very important part of a really solid motion to dismiss. And I added in there that, gee, who told me I had a $100,000 warrant for my arrest and their cops were looking for me? I'll answer that question, Judge. A drunken alcoholic reporter from Channel 8 KOLO TV News, which, by the way, is the same station that reported that I was intimidating and harassing witnesses after the last court hearing. Another bald-faced lie. I'll see them report too. So this is it. I'm going to do my due diligence, and I will also expound on anything that you guys want to talk about here on the live cast. But that's the update. And so there's where it stands. And as I stand, yeah.
Incredible. That was incredible. I mean, you heard it live, folks, on the air. You just heard it. So that was the live update from Stu Hanty for us on the case. That was brilliant, dude. Thank you for jumping in and giving people that.
I appreciate it. And I appreciate the time, and I'll yield back to you. I just want to make sure everybody had that update because
that's great. That's good stuff. Good stuff. Yeah. Definitely. Important content, for sure.
All right. Thank you, bud. I'll stop.
Thank you. The main point I would like to make regarding this statement is that if Roger was truly brain damaged from his accident, then why was he deemed competent to represent himself pro se in the current prosecutorial criminal trial being perpetrated upon him? It actually contradicts Eugene's alleged belief that he had brain damage. In light of this fact, the likelihood that Robin Renwick manipulated her father during and before this competency evaluation is far more likely the scenario that played out here. In addition, it holds water with the known facts of the case and inconsistencies therein perpetrated by Robin Renwick, Stephen Moss, and their co-conspirators. The next statement from page 3 of Deborah Frederick's competency evaluation states the following. According to Mr. Hillygus, Jean, after his wife's Alzheimer's disease began to progress, she became vulnerable to undue influence by their son, Roger. She became completely controlled by their son, Roger. At first, Roger was very helpful, according to Jean, coming over to help with meals, domestic chores, and his mother's care. Eventually, Roger moved into their home and continued to provide much-needed assistance. Jean is unclear how his son could move into their home while still being married. Which is odd. What is an interesting observation to make from this statement is that it does confirm that Roger was very helpful coming over to help with meals, domestic chores, and his mother's care, including moving into their home and continuing to provide much-needed assistance. The last sentence in this statement, however, does show an alleged lack of mental capacity, as it states Jean is unclear how his son can move into their home while still being married. This statement is a bit odd considering that one doesn't need to be unmarried in order for a caretaker to move into the same residence as the person they are caring for. Furthermore, we know that Debbie, Roger's wife, moved in with Roger to the residence to take care of Susan Hillygus, as it was more practical to do this than continuing to commute every day, which would save them time and money in regards to the commute. It also shows that Roger was responsible enough to take into account where he needed to cut costs from his own expenses in order to continue to be able to give his mother the proper care that was needed. The last statement from page 3 of Deborah Frederick's competency evaluation states the following. He also perseverates over his dislike for his daughter-in-law, Debbie, who he reports is uneducated, crude, and rude. It is a strong belief and possibly delusional that Roger turned my wife against me, and she puts in quotes, turned my wife against me, according to his statement. According to Mr. Hillygus, Roger engaged in an insidious plan to influence his mother, take over the family estate, and kick Mr. Hillygus out of his own home while isolating his wife. He stated, we had to have the police remove them. He reported that his son often had him sign blank checks and had placed him in a previously assisted living community against his will. The first thing I think we need to point out is where Deborah Frederick says in her statement, he also perseverates over his dislike for his daughter-in-law, Debbie, who he reports is uneducated, crude, and rude. What does perseverates mean? Well, we can find out with a simple internet search. And I have a link to what that means for you folks, for your convenience. According to this article by understood.org, perseveration is, many of us get fixated on an idea once in a while, but with some people, it happens more often. Perseveration is when someone gets stuck on a topic or an idea. You may have heard the term in regard to autism, but it can also affect others too. People who perseverate often say the same thing or behave in the same way over and over again, but they can get stuck on their emotions, actions, and thoughts too, and they do it past the point where it makes sense or will change anything. It can be frustrating for everyone involved, especially the person who's stuck. It's not that they won't stop, it's that they don't know how to stop. They may not even know they're perseverating in the first place. It's like they're stuck in a loop they can't get out of. There's a difference between perseverations and obsessions. Obsessions are more severe and are often part of mental health condition called obsessive compulsive disorder, OCD. In some cases, people may have both OCD and other learning and thinking differences like ADHD. People who perseverate aren't being defiant or stubborn. They have challenges that cause them to get stuck. They might struggle with managing stress, processing information, shifting attention, or putting the brakes on certain behaviors or thoughts. Perseveration can also be a coping mechanism for people when they feel overwhelmed, anxious, or not familiar with the situation. Based on the evidence and what we know and can demonstrate through the evidence we have already gone over, I would argue that the reason for Gene's perseveration over Roger's wife, Debbie, manifested as a coping mechanism in Gene's case due to feeling overwhelmed, anxious, and not familiar with the situation he was currently in, which was undue influence and manipulation by his daughter, Robin Renwick, who was spinning a narrative against her brother, Roger, out of spite and resentment. Furthermore, based on the next sentence in this statement, it is a strong belief and possibly delusional that Roger turned my wife against me. This statement by Deborah Fredericks shows that she knows there was a possibility that the belief by Eugene Hillygus that Roger turned his wife against him was very possibly delusional in light of his vascular dementia, as well as the fact that he was perseverating over Roger's wife, Debbie, as well as other times he perseverates over the same statement. For example, if you go through the full text of the competency evaluation by Deborah Fredericks, you will see that the statement Mr. Hillygus cannot name his first successor trustee is mentioned several times. This is indicative and consistent with manipulation by Robin Renwick perpetrated by her upon her father, which caused undue stress in a situation with which he was not familiar and did not understand, resulting in Mr. Eugene Hillygus perseverating multiple times during this interview and series of tests with Deborah Fredericks. Finally, the last two things I want to point out in that last statement from page 3 of Deborah Fredericks' competency evaluation is the statement, according to Mr. Hillygus, Roger engaged in an insidious plan to influence his mother, take over the family estate, and kick Mr. Hillygus out of his own home while isolating his wife. He stated, "We have had to have the police remove him." This shows that there was indeed an eviction that was perpetrated by Robin Renwick to get Roger and his wife out of the home. The motive for her to do so is because with him no longer living at the residence, she could then proceed with hijacking the Hillygus family trust and use the narrative she was being to do so. If you remember the video clip we touched on from the Stone Valley Care Facility body cam footage, you can clearly see her using this narrative to put forth her agenda, using manipulation to do so when speaking with the responding officer. As we can clearly tell by the responding officer's tone of voice when he says, "We will let them know," you can tell he smells bullshit from Robin based on that alone. This is inconsistent with what we have just established, or this is consistent with what we have just established based on Deborah Fredericks' competency evaluation. Furthermore, if Robin Renwick was telling the truth, we would not have seen her make the statement, "He's aggressive, he has guns," in the body cam footage from Stone Valley Care Facility, dated August 8th, 2019, in the manner that she made it. And finally, the last sentence of page 3 says the following. He reported that his son often had him sign blank checks and had him in a previous assisted living community against his will. Well, I can show you where we came across something very similar in Dr. Ken Elliott's evaluation from a year prior. Below is a cropped screenshot of the cover page of Dr. Ken Elliott's evaluation and diagnosis of dementia. And it says, and at one point he had an obsession with some form of internet cards which involved check writing. And this is what I was getting at earlier, how I was going to tie it in, folks. Following that, we have page 4 of the competency evaluation by Deborah Fredericks, MD. After carefully looking at the wording of this page, I found that we have a couple solid data points that we can show that back up our argument even more. According to the first statement highlighted on this page, according to his daughter, Robin, there was financial exploitation and emotional manipulation. She relates that Roger did move his wife, Debbie, in with Gene and Sue, then relocated Gene out of the home, Mr. Hillygus reported that he cooperated with MOOP but didn't understand exactly what was happening at the time, then hated the place he had been moved into. I probably went along with it, but he, referring to Roger, made it sound so good. My whole life has turned around. He did not understand that he would be permanently removed from access to his wife and is very resentful of the fact that he is not able to regularly visit his wife. Gotcha, Stu, gotcha. Okay, cool. Will do. The first thing worth noting here is, again, Deborah Frederick's own statement says, according to his daughter, Robin, there was financial exploitation and emotional manipulation. She relates that Roger did move his wife, Debbie, in with Jean and Sue and then relocated Jean out of the home. The first observation I want to point out here is that she admits, according to his daughter, Robin, there was financial exploitation and emotional manipulation. Again, this is hearsay and is what Robin is claiming. The word according from Merriam-Webster.com has 3 different contextual definitions. 1, in conformity with, 2, as stated or attested by, and 3, depending on. In this context, the second definition applies, because Deborah Fredericks is relating that Robin Renwick stated or attested, meaning it was a claim or opinion of Robin Renwick. Furthermore, she related that Roger did move his wife, Debbie, in with Jean and Sue. All of these statements are in fact true, and that is due to the fact that it was more practical for Roger and his wife to move in with his mother and father so that they could better care for Sue Hillygus. Furthermore, it should be noted that according to Deborah Frederick's own statement and based on the sentence structure, there are 2 separate sentences. One further mentioned that Robin said there was financial exploitation and emotional manipulation, but nowhere in that sentence does it say she said it was Roger. The sentence structure indicates this is a separate statement from the one that follows about the fact that Roger did move his wife, Debbie, and himself in with Jean and Sue. And due to this, we can only conclude that Robin Renwick only suggested this to be the case indirectly. Next, we have the second highlighted statement from page 4 of Deborah Frederick's competency evaluation. When asked about plans for the future, Mr. Hillygus reported that he would like to stay where he is currently living and his wife should move into an Alzheimer's facility. He states, I am getting older and I am moving into a dangerous area, cannot manage everything. He agrees that someone else should take over management of the trust and wants his daughter, Robin, to manage his affairs. I hope Robin will sell the house and get me out of the financial hole we are in. Although he is estranged from Roger, he still wants him included in the will because after all, he is still my son. He identified Darla, her husband, and his son, Randy, as trusted family members. Keep in mind, folks, these were the people that he did not want on the trust in the original trust document. So it's completely contradictory to what the original one states. So that's suspicious in and of itself. He was able to name all his natural beneficiaries. He believes everyone is named in his current will and cannot name his current first successor trustee. The 3 most relevant points I would like to point out from this statement are listed below as follows. 1. When Mr. Eugene Hillygus reported that his wife should move into an Alzheimer's facility. 1. I highly doubt he was in his right mind due to the undue influence by Robin Renwick. The statement Mr. Eugene Hillygus made according to Deborah Frederick's statement are inconsistent with what Eugene wrote in his termination letter on June 12, 2014 to Stephen T. Moss, Esquire. This letter is coming up shortly in the timeline. 2. Where it says in Deborah Frederick's competency evaluation, he agrees that someone else should take over management of the trust and wants his daughter, Robin, to manage his affairs. I hope Robin will sell the house and get me out of the financial hole we are in. Although he is estranged from Roger, he still wants him included in the will because after all, he is still my son. This is indicative of being under duress due to the fact that based on Roger's testimony, this whole competency evaluation caused him immense stress to the point where he developed shingles. In addition, the fact that he reiterated that he still wanted him included in the will because after all, he is still his son, indicates to me on some level he still had trust in Roger despite the fact that they were estranged. The last statement here says that he believes everyone is named in his current will and cannot name his current first successor trustee. Again, this is indicative of either Deborah Frederick's perseveration on this point or Jean's perseveration if Jean did in fact make these statements, which based on Deborah's fact of the inconsistencies with the dates and the spelling of the Hillygus family name, I would argue that the former is more likely the case. Next up, we have page 7 from Deborah Frederick's competency evaluation as it has the following statement. Conclusion, Mr. Hillygus demonstrates very limited understanding of his current legal challenges. In my opinion, he was very likely subject to undue influence and financial exploitation by his son, Roger. He does not demonstrate contractual capacity. He only demonstrates two of the three elements of his testamentary capacity. With regard to decisional capacity, his plans for the future for both himself and his wife appear logical and insightful. Illogical? I don't think so. Considering that she could have been staying at the home if they had not evicted Roger. You know, I just want to point this out. I'm my mother's caregiver, and she's got far better care being at home with me and in a familiar environment than she ever had at any of these freaking facilities. So I just want to point that out for folks, okay? I was able to observe medical decision making because he developed shingles after the first day of testing. Yeah, medical decision making that she freaking is the cause of. You know, shit. Although he understood that shingles was a condition that needed treatment, he did not understand or remember the treatment and was very confused over the medications that were prescribed. The first thing I want to touch on here is that, again, Deborah Fredericks states, in my opinion, he was very likely subject to undue influence and financial exploitation by his son, Roger. She makes clear to state it is her opinion. I would argue that opinions can be influenced based on a number of factors. One of them being that she has never even met Roger, according to Roger's own testimony, and the fact that the only information she was getting was from Robin and Jean during this evaluation. I find it far more probable that this opinion was influenced unduly by Robin's undue influence on Jean, and Jean's mental incapacity makes him even more vulnerable to influence that is undue. Furthermore, this supports Roger's claim that he developed shingles as a result of the amount of stress this evaluation put him under, which does hold water when you take into account the perseveration observed in this competency evaluation. And you can see it there for yourselves. Of course, always cite our sources. And finally, we have pages 8 and 9 from Deborah Fredericks' competency evaluation. In my opinion, Mr. Hillygus is unable to respond to a substantial and immediate risk of physical harm, to an immediate need for medical attention, and to a substantial and immediate risk of financial loss. It is also my opinion that he's been subjected to undue influence, financial exploitation, and medical neglect by his son, Roger. There you go, you can see that. Again, I would like to point out that Deborah Fredericks is repeating her previous statement regarding the fact that it is her opinion that Jean was subject to undue influence, financial exploitation, and medical neglect by his son, Roger. This is a third repeat or perseveration by her on this point. As we learned before about perseveration, I would argue that this was the result of Deborah coping with an unfamiliar situation in which she knew on some level was wrong. We also have her alleged signature. However, it should be noted that there is no date next to the signature, which in my view is suspicious. The next source for our forensic timeline analysis is opposition in part to motion for the appointment of guardian ad litem. As we can see, the arguments made by Woodburn and Wedge on behalf of Roger are consistent with my findings of the case and are as follows. Family members and attorneys involved in this unfortunate family drama are all aware that Jean suffers from dementia and that Sue suffers from the effects of Alzheimer's disease. Sue is represented by Gordon Muir. Steve Moss previously represented Jean. However, pursuant to the June 12, 2014 letter attached hereto as Exhibit 1, Mr. Moss was discharged. Jean is currently not represented by counsel in this matter. Despite the fact that Roger has been the acting successor trustee, Mr. Moss set his previously filed petition regarding administration of a revocable trust for hearing purportedly on behalf of Jean, seeking to appoint Adam Clark as successor trustee. Roger's objection to this petition was filed on June 18, 2014. The petition was set for hearing on June 19, 2014. Mr. Moss conceded at the hearing that Roger was a successor trustee, but insisted, contrary to the terms of the trust, that Roger be removed as trustee. Todd Travine, counsel for Robin Renwick, made an oral motion at the hearing for the appointment of a guardian ad litem on behalf of Jean and Sue. Roger hereby opposes that motion as to Sue because a guardian ad litem for Sue is not needed. She is adequately represented in this proceeding by Gordon Muir. Exhibit 1 of opposition in part to oral motion for the appointment of guardian ad litem is the next source in our timeline analysis. It is important to note that this exhibit contains a handwritten letter by Herbert Eugene Hillygus, dated June 12, 2014, expressly stating his wishes and intent to fire attorney Steve Moss from representing him, In addition to his explicit and expressed intent in his wishes regarding who he wants as official successor trustee, as the letter states, that person is his son, Roger Hillygus. And we can see it there, and we also quoted it here, and we're going to read it for you. Date, June 12, 2014. Dear Steve Moss, it appears as though you are not taking my verbal request to you over the phone, discharging you as my attorney. Seriously? Let me refresh your memory about the events of that call. My son, Roger Hillygus, the successor trustee of the Hillygus Family Trust, and I hand-delivered to your office, Secretary Cynthia, an original hand-signed letter by Roger, discharging you as the attorney representing me and the Hillygus Family Trust. At that time, we both told Cynthia to send us any and all personal property and a complete file along with the final bill. You called me the next day and we spoke about this, and I informed you during that phone call that I no longer need or wanted you to represent me or the trust. You told me to pay the final bill would be $2,000. I am confirming the discharge letter written by Roger. I agree with the terms and conditions of the letter. I am, however, disappointed that you are continuing to represent me after we mutually agreed to terminate our relationship. I realize that you believe me to be incapacitated and that you think you are protecting me from my son, Roger Hillygus. Nothing could be further from the truth. He is a successor trustee and the one I have always wanted to be placed in that position. So please consider this your official notice, discharging you as my attorney. You are to cease and desist from any further actions, hearings, or petitions with the court on my behalf or by representing any family member. Respectfully yours, Herbert Eugene Hillygus. Now, one would think, after all of this conflicting information on behalf of Robin Renwick, Steve Moss, and others, that it would be more that it would that's a typo, that it would be more than enough to make the court back down, and that they would do what they are supposed to in regard to the law and preservation of due process, which is clearly spelled out in the state constitution and U.S. Constitution. So your question may be, does the court do what's lawful and ethical under the law? Unfortunately, my answer to you based on the evidence is no, they do not. What they instead did shows absolute proof that the probate and guardianship courts here in Nevada colluded to steal the trust, property, and assets of the Hillygus Family Trust. Next on our list of sources for this timeline is the recommendation for order assuming jurisdiction over the trust, order setting pretrial conference. See all this for yourself, folks, and verify it. You can even go into the actual document here, and it'll take you right to the page that it's linking to or showing above it. See? Easy peasy. Clearly, in the recommendation for order assuming jurisdiction over the trust, order setting pretrial conference, we can see it says the following. Recommendation for order assuming jurisdiction over trust, order setting pretrial conference. The commissioner held a duly noticed hearing on June 19, 2014, based upon the petition regarding administration of revocable trust filed by H. Eugene Hillygus through his counsel, Stephen C. Moss, Esquire. Counsel Moss appeared at the hearing. Also appearing at the hearing were the following additional interested parties. Todd L. Trevino, Esquire, representing Robin Hillygus Renwick, who joined the petition. Sharon Januzzi, Esquire, representing Robert E. Hillygus, who opposed the petition. Not appearing was Susan Hillygus, co-settler of the trust, nor her counsel Gordon R. Muir, Esquire, although the court is informed that he is still counsel for Susan Hillygus. The matter is contested. Commissioner therefore scheduled the parties for a pretrial conference on July 1st, 2014 at 4 p.m. before Department 4 of this court. The Honorable Connie J. Steinheimer presiding. The commissioner made the following additional recommendations. Now, this next part is so obvious what they did and so incriminating it would be almost unbelievable if I didn't see the document myself. 1. The court assumes jurisdiction over the Hillygus Family Trust, dated August 17, 1993. 2. The court declines to confirm the appointment of any successor trustee, although the record indicates that the same may have become necessary based upon the incapacity of both settlers, H. Eugene Hillygus and Susan L. Hillygus. Instead, pretrial conference date was expedited so as to allow these issues to be addressed soon if necessary. And that's doublespeak for them saying that they need to rush us through so they can't get caught. For context, folks, pretty much. The court further declines to act upon the oral motions to appoint a guardian ad litem for either settler, and instead allows the opposing party, Roger E. Hillygus, to file his written opposition to that motion. Nothing in this portion of the recommendation, however, constitutes a finding that would bar a party from seeking further relief in this area or in continuing to pursue the pending petitions for appointment of adult guardians if the same becomes necessary or appropriate. And I just want to point out that in the in the matter of the Hillygus Family Trust in the January 2021 hearing, where they basically they pin all the freaking the legal fees on Roger. That's why they made this statement, so that they could do that later, folks. And I just want to point that out. The commissioner's recommendations should be extremely scrutinized, considering how brazen they were about this ruling. Was part of the reason anyway. Clearly, we can demonstrate, and I'm talking about the part I was referring to a minute ago. Clearly, we can demonstrate through this filing that the following is true beyond a reasonable doubt: that the court ignored exculpatory evidence, in this case beyond any reasonable doubt, of it being by accident or unintentional. 2, that the court used the divide between the Hillygus family for Robin Renwick and to unlawfully and unethically take advantage of a situation that they themselves engineered with malice forethought to steal the Hillygus family trust. This is evident by the fact that they declined both settlers, Robin Renwick and Adam Clark, the oral request for a guardian ad litem, and the fact that they acknowledge that this does not mean they won't do so in the future should it benefit their agenda. Admin note: this will be explicitly demonstrated with full video evidence in the extended version of this timeline. That the court and many bad court actors, including but not limited to lawyers, petitioners, judges, and many others in positions of authority, and that these aforementioned individuals colluded and conspired to fraudulently case fix using their positions to abuse their positions of authority in order to steal the Hillygus family trust. And finally, we can clearly see on the last page that it states the following: electronically filed with the clerk of court using the ECF system, which will send a notice of electronic filing to the following: Jason Morris, Esquire, for Roger Hillygus; Todd Torvinen, Esquire, for Robin Renwick; Michael Springer, Esquire, for... Now, this is important to note. They misspell his first name here. And this is the only time I've seen them do this. Hubert E. Hillygus, H-U-B-E-R-T. Okay, that's misspelled. Stephen Moss, Esquire, for Hubert E. Hillygus, H-U-B-E-R-T. That's odd, but there's a reason they do this. This goes back to the inconsistencies with the dates and the other spelling of the last name. One thing I want to point out, which backs up my argument that they were well aware of what they were doing, is the fact that, again, we have a misspelling of Eugene's given name, which is spelled here as Hubert, which is clearly not correct. Eugene's given first name is Herbert, not Hubert. Again, I make the point: why was there such an obvious typographical error, and how did they not catch this before putting it on court record? And I say to you, this was done by design. Let me put this into layman's terms that most will understand. How does one avoid accountability when one is knowingly and willingly committing fraud upon the court? One intentionally makes certain typographical errors with dates and names so one can claim after the fact that their intent was something other than it actually was. This is what I was referring to when I mentioned certain legal loopholes at the introduction segment of the timeline video. Our next source is the Herbert Hillygus obituary. The relevant data point I want to point out from this obituary, okay, which is you can access right there if you want to read the full thing. From this obituary was actually discovered by accident when doing the narrative on this obituary for the initial abridged timeline video. In the second to last paragraph of Herbert U. Hillygus' obituary, it clearly states he is survived by his wife, Sue Hillygus, sons, Randy Hillygus, and son and daughter-in-law, Roger and Debbie Hillygus, daughter, Robin Renwick, grandchildren, Darla Clark, and her husband, Adam Clark, okay? And this actually takes you to document where it shows that ruling where they made him a successor trustee, or secondary successor trustee, or yeah, anyways. And Landon and Sophie Renwick, great-grandchildren, Seth and Gavin Clark, and friend Sammy Brooks. As we mentioned in the video timeline at the top of this article, could this be the same Adam Clark as mentioned in the First Amendment of the Hillygus Family Trust document? The answer to that question is yes. It is the same Adam Clark, and furthermore, it should be noted that Adam Clark is also much like Robin Renwick in the real estate business. This effectively establishes and confirms that the court had not only the motive to commit these crimes, but also had the means and financial incentive to do so as well. In any criminal court of law, this level of evidence in establishing motive, means, and financial incentive effectively makes the case once you can prove these points, or those points, beyond a reasonable doubt in the context of who, what, where, when, and why. which I can attest, as I am sure you, the reader, can clearly see up to this point we have established. You may think that this is the end of the story, but you would be wrong. This real-life American greed corruption story goes much, much deeper and much, much farther up and down the ladder of different levels of government than any of us ever imagined. Furthermore, we can prove it all and have multiple backups of all the evidence we have in multiple secure locations with multiple people, effectively creating a dead man switch. And yes, we will expose it all in our next extended video timeline and corresponding extended version of this article. Justice is coming, folks. With that being said, let us move on to our next source in this timeline, which is the Declaration of Homestead document. You can see it there for yourself, the unedited version. You can also see the highlighted screenshot there. As we can see from the above homestead document regarding assessor parcel number 552-17104, Roger had the foresight to homestead his trust property. This represents a real dilemma for those bad court actors, which is part of the reason they are persecuting Roger so aggressively and unjustly. But it is not the sole reason, and in fact is just one aspect of a much deeper rabbit hole, which connects the dots and establishes that the same tactics were used to take Angela Freiner's daughter through the family court system out of St. Louis County in St. Louis, Missouri, in her case, as were used in the Hillygus family trust case, verbatim. They both were predicated on false, unlawful TPOs. Both used the family or guardianship courts to commit their crimes and push them through these corrupt judicial court systems. In both cases, there was no valid justification for the court to do so. And in both cases, they tried to silence their victims using malicious prosecution, which is a criminal felony. Angela successfully called their bluff in her case regarding the corrupt court's malicious prosecution of her by the court. Currently, Roger Hillygus is being unlawfully and unjustly maliciously prosecuted, and it must stop. This is a threat to all of us. If they can do this to Angela Freiner and Roger Hillygus, as we have just established, they can do it to anyone they please until we call them out and put a stop to this madness. However, I digress. Back to the point I was making about why the homestead document is relevant to how they are reacting currently with this malicious prosecution against Roger Hillygus. Here is why this is a huge dilemma for them. And we have take you to the actual screenshot we highlighted, and you can also go to the original website link that takes you there where we got the definition from. And as we can clearly see, according to Nevada state law, a declaration of homestead provides, when you record a declaration of homestead, Nevada law protects the equity in your home up to $605,000 from general creditor claims, unpaid medical bills, bankruptcy, charged card debts, business, personal loans, accidents, but would not preclude a seizure or forced sale of your residence from general creditors if your equity exceeds the $605,000 amount. The creditor may file suit and can record a judgment lien against any real property you own. Recording a declaration of homestead protects your principal residence up to the statutory maximum. For example, if the value of your home is $645,000 and you have a first mortgage of $485,000 plus a second mortgage of $10,000, the equity is $150,000. Why is this important, you ask? This is important because essentially this homestead declaration gives us a legal avenue to file liens against these bad court actors. Furthermore, under Executive Order 13818, this allows us to go further and seize these corrupt officials' own property, assets, and property under the law. By the time we finish with the extended in-depth version of this timeline video, timeline and the corresponding article, we will have made the case beyond a reasonable doubt on two different fronts that this RICO racket is being perpetrated by two of the very institutions we thought could be trusted to uphold and defend our inalienable rights as set forth in our respective state constitutions and the Constitution for the United States of America. This will effectively establish probable cause and set the precedent, in addition to paving the way forward for us to take back not only our nation or nations, but to also take back our planet from these corrupt tyrants. This is a historic moment, folks. Remember this. Let it sink in. Remember where you are in this moment as you hear or read this. And above all, ensure you pass this knowledge down to all generations to come to ensure humanity never, ever has to go through this ever again. Now for our conclusion to the abridged/short version of this video timeline and article of the Roger Hillygus case. From this point on, I will tread a little more lightly on the density of my writing here, as I want to ask you, the reader, listener, or viewer, to consider and take some time out of your day to look at these documents and these points that I am about to point out regarding why the federal habeas corpus exhibits and the corresponding document filings hereafter are relevant to our respective state and U.S. constitutions, and what the term inviolate forever means in relation to them and how it applies to our current predicament. Here are some and this is the federal habeas corpus exhibits 1 through 5 for jury verdict per Article 1, Section 3 of the Nevada State Constitution as featured in the video, and some corresponding screenshots for you. Here are some corresponding screenshots below for your viewing ease and convenience of user independent verification. Okay. But this is a little homework I'm giving everybody. I want people to just take a little time out of their day to kind of become familiar with some of this, just so they understand their rights, what their rights are as far as a jury goes. Consider a moment what the term inviolate forever means to you. Then apply it to the context of the federal habeas corpus exhibits 1 through 5 for jury verdict per Article 1, Section 3 of the Nevada State Constitution shown above, and the relevant aspects and points it makes therein. Next, I want you to look at the next 2 federal habeas corpus documents presented below and do the same. Following that, we will look at the definition of what inviolate means, and I will have you go back and apply what it means as it applies to these documents, again, having the known definition of inviolate forever. Consider this a little homework for you to do when you have the time, or make the time to do so. I have made it easy to prove all of this evidence in such a way that it is irrefutable and cannot be denied. But what's important to note about how I have come to this point in my journey is that I had to put in the work, which means the only way we can truly fight this information war effectively is by empowering ourselves with knowledge and using the tools we have to do so in a productive way that will actually empower us and allow us to put an end to this corruption globally once and for all. Where we go one, we go all. Next, we have the notice of jury verdict. Case numbers PR 14-0025, GR 14-0159, Second Judicial District Court, Nevada County of Washoe, and these are the ones he got when he ended up having to go through as a people's jury because the courts wouldn't provide him one. And that is our right, folks, to do so when the court refused to give you a jury trial in any case, in any court of law, whether it be civil or criminal or what, we're entitled to a jury in all of those, and when they refuse, it is the people's right to do one of the people by the people. Notice of judgment. The encumbrance of 2685 Nob Hill Drive, Reno, Nevada 85906, presiding judge Ethan Walker. And this is another relating to this, that they're calling it out, the people's jury, folks. Let us take a look at what the definition of the word inviolate means. Inviolate. According to this definition of inviolate, courtesy of vocabulary.com, it means the following. Inviolate. If something's inviolate, it's sacred and must be protected. If you make an inviolate promise to your sister to never reveal her secret superhero identity, it's one you must honor and take very seriously. Inviolate comes from the Latin word inviolatus, meaning made up of, in meaning not, and violare meaning violet. So inviolate describes something so sacred or pure that it must not be violated, and can be used to describe fundamental principles or rights, such as the inviolate right of free speech, or in this case, the inviolate forever right of a jury trial. But it can also describe things that must be kept safe and pure. You might believe that the natural coastline outside your city should remain inviolate and not be developed. Now, before I wrap this abridged short version of the timeline analysis and its corresponding article, which you are reading or listening to now, remember that brief homework I wanted everyone to take some time to do for themselves? Well, folks, have at it. The world is at our fingertips. We just needed to realize it and take back our power. This short bit of homework will help you understand, and at least those of you who don't already know, how powerful we are and what we can accomplish when we work together as one unit, as one unified people, and also give you a glimpse into the power of our organic constitution as it was originally intended. Below, we have the full, raw, unedited versions of the body cam footage from both the Reno PD from 8/8/2019, August 8th, 2019, in addition to the Stone Valley Care Facility raw, unedited body cam footage from August 8th, 2019, followed by the full, unedited House sale hearing they held the day after with Judge Ethan Walker from August 9th, 2019. And lastly, we will wrap this up with the proof of our final source for this abridged / short version of the timeline, which is the proof that Judge Breslow has been acting as a judge for the last 2 years at least with an invalid bond. Due to the length of the original body cam footage and house sale hearings, I will let you look at these on your own time. You may even feel free to download them and make hard copies for viewing offline if that is more your preference. This information belongs to all of us because it has been perpetrated on all of us and affects every single one of us. Alas, I give you, the people, back to you what was wrongfully taken and the means to do so for yourselves. As they say, knowledge is power, and with great power comes great responsibility and the ability to affect great change. With that being said, let us get straight to that invalid bond so we can bring it home, shall we? You may click here to have the webpage automatically skip the body cam and house sale hearing footage and take you straight to the hearing from August 23rd, 2023. Source from our Nevada judges. YouTube channel, followed by the embedded PDF version of the 2 pages featured in the video accompanying this article that show the invalid bond, so you, the viewer, reader, or listener, can see the evidence with your own eyes or ears. And so you just click there, and it takes you right to the hearing from the 23rd of August here, where we're going to hear Stu call out the judge on his invalid bond, and then I'll show you the bond.
Judge, under the Sixth Amendment, I'm allowed to represent myself.
Well, let's not talk about whether
okay,
no, hold on. Let's not talk about whether the court should exercise its discretion or make a finding. Is that what you want to do? You want to represent yourself?
Correct, sir.
Yes or no?
Yes.
All right. I'm not taking that up now. How come? I don't have time for this. It wasn't set for this. We're on the eve of trial. I have other things to do. However, I will take this matter up Monday morning at 8:45 a.m. I've already set a hearing on the motion to quash. We'll take this matter up first. And then if you end up representing yourself, we're going to go right into the motion to quash with you being self-represented. If the request is denied, we're going to go right into motion to quash. Mr. Silverberg remains your counsel.
Do you have a bond to sit on the bench, Judge?
Pardon me?
Do you have a bond to sit on the bench?
So that's enough, Mr. Hanty. You can have a seat.
8:45
Monday morning, Mr. Hanty.
I understand that, Judge. This court has forced counsel upon me, and it is violation of Rule 1.16 and the Sixth Amendment.
Okay, Mr. Hanty, thank you. I understand your position. You're wrong. You're wrong. You're wrong in many different ways. You're also being disrespectful to the court.
Sit down.
You're being disrespectful to the court, Mr. Hanty, and you're also trying to mess with the proceedings here. This is a Wednesday before the Monday trial. Now, I will give you a hearing. If there's good cause, I will consider it, but it's not going to be today. Mr. Silverberg, anything else on that issue?
Your Honor, I just know that I'm guessing the state would agree that a decision on Mr. Hanty's position sooner rather than later.
It's sooner. I'm busy today. I'm busy tomorrow. And Friday, I've got commitments that take me out.
Okay. Invalid bond of Barry Breslow dated January 4th, 2021. Okay. You can clearly see it for yourself here, folks. We also have a link. Oops, that one did not open it in a new tab like I was hoping it would. That was the one I missed. Anyway, it doesn't matter. Let me just go back down here for you guys. Alrighty, let's see, here we go. Sorry, folks, I'm just going to open it in a new tab. There we go. So you can see for yourself, there's the crossed out portion where it crosses out Justice of the Supreme Court, and somebody hand wrote and Judge Second Judicial Court, which is completely an invalid legal document now because of that. It makes it completely invalid. It's the same reason that when you sell your car and you have to do the title transfer and you fill out, if you fuck up on the paperwork, you have to start all over from the beginning. The same reason that you have, that is the reason that you have to do that, which makes this invalid, folks. That's what you need to understand. That's what's important here. Okay, so let's go to this last little portion so I can close this out, and then we have a bonus for you guys that you'll all appreciate. And as we can all see, and then we'll take calls for the remainder of the next 15 minutes until until we have to close out, which because I gotta go make dinner and stuff in here in about 15 minutes. But we'll take calls if anybody wants to call in. And as we can all see from the embedded PDF of Barry Breslow's invalid bond above, this is an invalid bond because when it comes to legal documents of this type, such as a bond or even or even a title transfer of a vehicle, which I'm sure everyone here has had to do at least once. If there is any type of crossing out of any portion of such a document and penned in by hand, this makes it null and void because you cannot verify the chain of custody. That is why if you screw up on an automobile title transfer, you have to start all over with a brand new form because it becomes legally invalid by definition. A little bonus for all of you reading and seeing this. Here is a recorded call with Roger from September 17th, 2023 between Matthew and Roger.
Call has been accepted.
What's up?
Hey, so yeah, I am calling you back because there was a couple things that I wanted to discuss with you. One was I sent you a message yesterday.
Yeah, I got it.
Okay, so I can't even remember exactly what was in it, but I know that it was about all the things that they're doing to me and others. But
oh, the harassment and the rest of it. The well-educated gentleman that was having fun with your last name. Yeah, I got all that. You had actually spoken to that the previous day anyway. Most of what's in that text.
I did.
Which I recorded. Yeah.
I did, but I like to follow that up
Yeah.
with something in writing because, I mean, I can say it to you on the phone, but when I type it,
Correct. I'm the same way.
the other thing, every email that I've sent you in the last 10 months or more, from Missouri to here, when I talk about what a malicious prosecution, that's a felony crime. That you can do prison and you can pay a fine. I mean, and that's what's happening. It's absolutely what's happening in this case. But they're not going to admit, they're not going to police themselves, they're not going to put themselves in jail. They're going to try to cover it up, they're going to try to,
Here's the problem. Here's the dilemma for them right now, Roger. And this isn't my own perception. This has been volunteered by a number of people, both legal, professional attorneys and other that have been watching the antics for the last 3 years, but in particular the watershed that took place in your April 20th hearing when you spoke candidly to your situation really for the first time, because you were silent for the most part up until then, till April. You didn't furnish a lot of details prior to that. But since April 20th on, it's been falling apart really fast. And it's embarrassing. It is embarrassing to the state of Nevada, and it's embarrassing to the government from the top to the bottom. This is a bad legal case. A really bad legal case for any prosecutor, for any district attorney's office that would want to affix their label on this, their moniker on this. So again, it's excruciating to watch, because I see the public defender's office sitting on the sidelines. They do nothing.
Right.
They do nothing.
Right.
They are absentee landlords, and actually, as bad as the judge is in this case, and he's committing felony crimes, we know he is, it's the attorneys that really are absolutely the most reprehensible for their inaction.
So, you know that it's because there were so many, and when I say so many, there is an accounting that I did that has like a lot of exhibits. If you were to go back and find that accounting in the civil case, and it has quite a few exhibits.
Oh, it has.
There's like 50 attorneys that might be a little bit high, but I spoke to so many. I met with so many. I paid so many, so much money. There's so many of them in a certain firm. 5 or 6 in this firm. 3 or 4 in that firm. And now in the second judicial district because it's so corrupt.
Correct. And I have heard that. I have heard that from so many people, both inside and outside the state.
Yeah, no, there's no rule of law. They don't follow procedure. They don't follow rules. They don't follow the statutes. They don't follow the law. Your rights. They do whatever they want, and it's the good old boys. All the attorneys, and no attorney's going to go against this attorney. So you get in a civil case, and if it gets down the road too far, you can't turn it back around.
Correct. No, and I've heard it a lot from the people in California too. And boy, oh boy, is that saying a mouthful for the people from California, because they've got their own problems. But I have heard from numerous individuals, both within the legal profession and outside of it, that said that is really a very unique state. Well, you made the conscientious decision not to be in it, and nobody blames you after what happened to your co-defendant that was being abused, for you to say, hey, you know what, I've lost everything. My mother and father were killed as wards of the state. My co-defendant is in shackles, he's in jail.
Call from an inmate at a correctional facility. This call is also subject to being recorded or monitored, except for privileged communications between attorney and client.
Thank you, honey.
We're recording this as well.
Yeah, I enjoy that. I enjoy saying that every time she pipes up in the middle of the conversation to try to break your train of thought. But yeah, I would have done exactly what you did. What else did you have going for you? You lost everything. You wanted to start a new life and a new way out and a fresh perspective, and you moved to another state. Who wouldn't have done that?
Yeah, right.
Who wouldn't have done that?
Yeah. Hey, the other thing that you and I discussed at one time is that, and I know you're moving mountains. I mean, you're doing a lot, but there still are a lot of people that I did meet over that year that are I don't want to say they're influential, but some of them are. Like Ben, I know I mentioned Ben Barlow, and he's in my phone. He's in Utah. He's on TikTok, and he's got millions of followers, and he knows me. There's Marcia in New Jersey. She's got a lot of people.
I spoke with her, and I actually was, I called her, and she was transitioning when I spoke to her the last time. She had a family matter that was personal, and she just said, Matt, I will get back to you, and she never did. But I think with the way things are going right now, Roger, you don't need a lot of help. This has gotten a lot of attention, and like I said, if I were in the legal profession in Reno, Nevada, I'd be very concerned for whatever reputation I have left.
Right. You and I never really talked about Marcia. The one you called was, oh gosh, what was her name? She was in New York area.
Yeah, the one that has the radio show.
Yeah, no, that's not Marcia. So Marcia's another one that's in New Jersey. The one that has the radio show, I'm trying to think of her name right now. I'm drawing a blank on it, but that bugs me that I couldn't think of her name.
I can't. Oh my God, man, I can't even begin to imagine being locked up.
I know that when you called Bobby Lawrence in Pennsylvania, he was kind of wanting to be a little distant. And
Well, he was leaving the country.
that was an excuse. He wasn't leaving the country.
He didn't want to be bothered. Yeah.
Yeah, no, he's trying to cover for some other people in Texas that got him involved in what he was doing, going around the country. But a lot of what they're
Denied.
completely kept from the people, and kind of they put their own spin on it. The people that win put their spin on what our history is, and there's a lot of history that we don't. People are just naive to.
Be careful what you declare as win.
Well, the victor gets to rewrite history in there. I mean, that's been going on for thousands of years.
Yes, it has been, but when you deprive equity so inordinately, and you deny, when you say you're one thing and you do the opposite, over time it destroys everything that you otherwise would be, and the trust is lost. The trust is diminished. It's distorted. It gets destroyed, and you can't have a thing as genius as the U.S. Constitution and be the opposite of it. You can't. And your case is emblematic of all of that. How can they say they're serving justice? How can they say that they're equitable in any of the things that have taken place for you and Stewart? They can't. It's been total. It's been a total fraud.
You know, when they did what they did to Stu with his ex-wife and father-in-law and the FBI and all the people that was all hearsay. That whole hearing was all hearsay, and he had an attorney at that time that didn't make those objections. And that should have never gone forward. That was all about that ankle bracelet, and it's just he was railroaded.
Well, you do know that he was not notified by court services when he chose to miss his hearing. He was notified. He was notified by a news desk. How is that possible? Who notified the mainstream media that he had a $100,000 bond on him, bail amount, and a bench warrant for his arrest within 2 hours of missing his hearing?
Right. No, they did the same thing to me, and that's a violation as well.
And it's a violation of NRS 199.335 that says you are the one to voluntarily commit to coming back to the court within 30 days. They give you that.
Sure.
And they took that away from both of you.
Right. No, this is what they do every day to the citizen slaves, the people that don't know any better. They violate their Fourth Amendment rights. They violate their First Amendment rights. They assault them. They arrest them. They false imprisonment, false arrest. I mean, this is how they operate.
And I'm sure there are some bad ones in there, but I know there are a lot of people that are innocent that are also in that jail.
There are others that have been wronged by the cops, and by, like I just said, they violate your rights. They illegally search your car. They illegally pull you over. They illegally track and trace you. They illegally arrest you without probable cause.
Correct.
It happens all the time. Anyway, so I guess what I was saying is everything that I've written, all the emails that I've sent you explaining what they've done is these are crimes that they've committed against me. It is a malicious prosecution, but they're not going to police themselves. They're not going to arrest themselves.
Well,
This call will be terminated in 1 minute.
I have a sneaking suspicion, and again, I have no way of knowing this, but I think the big brother here in Washington is providing some oversight, and I think that's why whatever you're going to hear Monday or Tuesday is the reason why this is moving in the proper direction now.
Right. Well,
but they're not going to reveal themselves. You do know that. because they don't want to be they're involved, but they don't want to be involved to the extent that they're revealed or they're identified for the crimes they've committed as well.
Oh yeah. So speaking of that, have you ever gotten the appeal for the FOIA?
No.
Okay, folks, there you have it. That was the article. I hope everybody enjoyed it. Stu, you want to briefly give a little bit of context on the homestead document and what you were mentioning in the chat briefly for our viewers?
Yeah, I talked to a buddy of mine who's done a real estate business here in the Reno area for at least 2 decades that I'm aware of. And I brought up the homestead deal, and he said it does not protect the house from being sold out from a person. But I asked him, well, does that person, and I put the scenario out there involving Robin and Susan, and I said, wouldn't her name have to be on the trust for her to allow? I mean, she's not getting a acknowledgement from Susan that it's okay to sell the house, but they're rushing the process, which leads me to believe, based on law enforcement, they're trying to get this shoved under the door quickly as possible. He said, well, that would be a problem if only if Susan was deemed mentally incompetent, which of course we don't have any documentation to show her what stage of Alzheimer's. If I'll go on the fact that she had it, but to what degree. Now, speaking from experience, I saw my mom go through all 7. So Susan was nowhere near my mom when she was in her last days of life. So I'm saying I think that if Robin's name is not on the deed of trust, and that whoever is the guardian, I think the guardian has a play, and I got to look into that a little bit more. Would a guardian have a play in allowing the sale of the house? But it's got to be some acknowledgement. There's got to be a proxy for Susan. There's got to be a lot of things that come into play, and I'm just speaking from a logical standpoint. I don't see it. I understand what he said about the Homestead Act. I get that, but now my question is does this allow whomever without legal authority to sell a house from out away from a person who's not been deemed mentally incompetent by any medical doctor, or there's no documentation to show that? So basically, as I can see it from that standpoint, there's a problem. So I got to dig into it a little bit more. He didn't have the answer for me on the part 2 of that. He did on part 1, but not part 2. So that's where we stand on that.
Further investigation is needed.
Yeah, further investigation is needed, and I think it warrants further investigation. And I'll try a different route. Yeah, but other than that, you've got the updated information that I talked about earlier, and we'll see what happens. I will say this right now, that until that prosecutorial or that motion to dismiss is filed with the court system, and the prosecutorial misconduct allegations, as well as the malicious persecution and prosecution, are properly addressed, I ain't signing a goddamn thing. And that's the way it's going to stand. And if Amos says different, this is, well, gather up your artillery, because we're preparing for battle.
We are, and we're ready for battle.
Yeah, and there's other things going on that are left in an unknown status for now until we get it all dialed in. So, like I said, I see number one, I and both Roger and I see the motion to dismiss. We vet it carefully. We look at it carefully. I will say that I have seen the revised version of the new and improved plea agreement, and I don't agree with that one bit. So there's got to be things that have changed. And I just want to say before I conclude is that if they want to play games with people's lives, well, let them try. They have done their due diligence, but Roger's still alive and so am I. So that being said, I thank you for allowing me to speak. And then that's it, Steve. I got nothing else to say right now.
Thank you for providing that valuable information. That's good, important information for our viewers to have. Very much.
Yeah, appreciate it, bud. And thank you for doing all you've done, and everybody else that's done their part. You have some more hills to climb before we tackle the mountains. and we'll do it. So
we're ready though. We're ready. Yep. Good hunting. All right, folks. So we'll Allie, you want to speak on that at all? And Kathleen, you want to say any words on what you thought? And then we'll open up the phone lines for a few minutes before we wrap it up.
I thought it was really, really good. And there's got to be a little bit more to Robin Renwick and her real estate license, and there has to be something that she overstepped in that whole process with the homestead and her being the realtor. We just have to look into that a little further.
Agreed. Yeah, we have to find out what's going on with that. More specifically, agreed.
We'll
Steve-
find.
Oh, go ahead. Hey, so, hey, Roger mentioned the civil suit has a list of
Yes.
people.
We
Do you-
need
do-
to. We need to. I believe I have a copy of it. So we'll go look into that and start digging, see what we find.
All right. And truth be told, I think we need to start from the beginning.
Well, we're going to. That's why this is the shortened abridged version. This is like this introduction for people for the introduction to the case. But we're going to be going like to the final, and the final extended version is probably going to be like freaking 6 hours long, maybe. I don't know. It's just a lot of evidence, folks. But we're going to go through it. So.
I think if we start with the characters of Roger and Stuart and identify who they are, first of all,
Yeah.
and the ones that we've known to grow and love.
Yeah, definitely. I think it's a good strategy. We should probably just set strategy off the air, though.
Yes, please.
You don't want to reveal your strategy to your enemy ever.
Never.
Well, I appreciate
the art of war. Go ahead, Kathleen.
I say I appreciate all of your work. I know this was a lot.
I enjoyed calling these bastards out. This is fun for me. I live for this shit. Truth be told.
You're so creative. It's fun after, when you have that kind of.
It is fun. I would agree. Yeah.
We appreciate you, Stephen.
Giving
Thank you.
people a voice, man, and giving them standing up for people that need to be stood up for that have been wrong. It's fucking not right. Somebody's got to do it. You can't just stand by and do nothing.
Right. I couldn't live with myself, or none of us could. Yeah, you just because like you said, I mean, or like that song says, if we don't stand together, we'll hang separately, and they want us all dead. So however they get us, they don't really care.
Yep, you're right. You're absolutely right on that. It's exactly how it seems to always go with tyrants. That don't you know?
Right. But like you said, they underestimated us. A lot.
Big time. Big time this time around. They really underestimated us this time.
Mm-hmm.
I think they're in that deer in headlights moment right now where they're realizing that they're fucked. Excuse my language, but they're screwed and they know it.
Yeah, they are used to bullying the elderly or children or the disabled that don't have the capacity to fight back. So
right.
We're the vigilants.
They don't know what to make of us. Anyways, I digress. But yeah, I'm having fun calling these bastards out because I'm really toying with them, and it's like they're amateurs. Like, come on, dude! If you're gonna freaking do that kind of shit, at least cover your fucking tracks, freaking amateur.
You're working circles around their nonsense.
Dude, I am, aren't I? That's the beauty of it. Man, it's too funny. It really is too funny. You couldn't write a Hollywood script this interesting.
Do you think you have that list on hand?
I don't know. I have to look for it. You mean talking about the financial one from the discovery he was talking about?
From the civil case with all of the
oh yeah, we're gonna have to look at that later because I gotta go run to the store and get more tobacco and then make dinner and shit here in a minute. So I want to to maybe open up the phone line for maybe 5-10 minutes, real quick, for let people give a chance to all.
Do you have that to you, or do you need it? I forgot to send that, Kathleen. I apologize.
Oh,
Do you have? You do have it, Ali?
Just in case. Yeah. If we don't.
Yeah, I have.
I think I might have.
Forwarded
it.
it.
Sure.
Please send it. Yes, thank you.
I'm sorry, I forgot. We were talking about so many things. I got sidetracked.
There's
I'll do it now.
To go
I'll
over
do it.
this case. You know what I found when I was putting together an article, and I was looking through screenshots of stuff that I had originally put together for the timeline that I didn't use, right? And I'm looking, I'm like, I don't remember putting this together, and I'm thinking, oh, I must have, so because freaking it's there. I was like, that's how much stuff there is involved in this case, folks. It's a lot.
It is. They love to drown you in paperwork. It's ridiculous.
It is. It's a lot. It's a lot. But we streamlined the way I designed a way of presenting the information. It's kind of helped streamline the process. I know it's not been done before, as far as I know. So,
Ali, do you have the list of witnesses that they've been handed last? I think there was 71 different witnesses that they wanted to call against them.
That's what you mean for Staggy? Yeah, that's what I'm going to find and send it to you.
Oh, that's what you're talking about? Okay, good for that one to get sent. I'm asking also, Roger mentioned the civil case, and it has...
That's the one I'm talking about, the civil case. Oh, okay, wait. Oh, you're talking about the criminal case. And the civil case, I don't know. I do have the one for the criminal, but I don't think I have the one for the civil.
So
but I can find it.
Lines now, and we got it's 5:11, and we're gonna wrap it up around 5:21, so I can get going. I gotta go run an errand, make dinner. But
okay, thanks, Stephen.
Opportunity to call in for just 10 minutes, please. And then if you want to call in and ask questions, feel free to do so. I do gotta wrap it up in about 10 minutes, so I can go make dinner and stuff. But I would love to hear from people, and we need to look into that document for sure. The financial thing he put together for sure. We're going to include that in the extended version as well, folks. So we'll get back to you with that information very soon. That timeline, right, Kathy, Kathleen, and Allie, right?
Sure. Yes, we will.
Yeah, we can talk until somebody calls in. I was just trying to announce that we were opening up the call the lines. That's all.
So much to talk about.
Oh, I know.
Where do we begin?
Oh man, there's so much in this case. I pulled a couple on later a couple weeks ago, finishing that video timeline, and then I didn't do that again this time. I was like, fuck that shit. That was too much on my body. I was like, I'm gonna make sure I get my sleep from now on. So.
Oh, that's too much. I know. I was worried about you. I'm like, Steven, get some sleep. Jeez.
I used to do that back when I was younger. I just don't have it. My body can't take it no more. My body's
no, you gotta have balance.
Can't take it no more. Yeah, I know. I've noticed that my body's not as young as it used to be. I'm like, fuck, man, I'm not as young as it used to be.
That's what I do. I go for a while, and then all of a sudden it's like, okay, you're gonna go to sleep now for about 10 hours.
Right. You basically leave your body no choice, because by the time you're at that point, you're seeing shadow people, and like you're having delusions of grandeur, and having a hard time staying focused, and you're like, oh, I'm so fucking tired.
Yeah, it's not good. It's not healthy.
No, it's not. It's not at our age. Oh shit! I noticed I had to switch from energy drinks and freaking stuff that's not too great for you and I drink mostly carbonated water and sometimes coffee, and sometimes I'll have a couple other drinks, but not that much, and there's my energy level is just through the roof compared to where it used to be, so that helps. I'm always hydrated because of it too, so
yeah, you got to stay hydrated. So I found this witness list from Roger. I'm going to send to you too, that it seems he thinks is important.
Yes, it is important. And that witness list and the list of attorneys, judges, whoever else was in the civil case, there was many of them. I wonder to cross-reference them. I don't know where to find the civil case yet. Matt might have.
Well,
let
check
me
your
announce the
email and
call.
see if that
Lines are
helps. What I just sent you. I'm sorry, Stephen. Go
I was going to say,
ahead.
I forgot to announce the number for people. If the call in line, folks, is 702-482-8620. If you want to call in, feel free to call in and ask a question or make a comment on what you think and the Hillygus case or whatever. Whatever you want to talk about. We'd love to hear from you. Go ahead, Allie.
Oh, no, that's okay. I just sent you something that I found from Roger to Matt, and it's a witness list from Roger.
Okay, cool, awesome. That will be helpful. I hope I tied it together pretty well for that article. What do you guys think of how I wrapped that up? I'm just curious. Honest opinion.
How you wrapped it up? I thought it was good. I mean, we're always learning and discerning, and
on the Constitution, yeah. Because I think that's important that we emphasize that. Don't take our word for it. Look into it for yourselves.
Yeah, exactly. People don't, if they don't want to believe what you're saying, then do your own research.
Right. Exactly. And when okay, well, here's the evidence. See for yourself.
We encourage it.
Of course we do, because the evidence will speak for itself. It always will, especially the truth.
Yeah.
Well, I mean, it looks like we do have them on the defensive, at least. That's for sure. I mean, we got that live update right in the middle of the article. That was pretty cool, wasn't it?
Ollie, go ahead.
No, go ahead.
That email, I had not seen that before. Thank you for it. But I was more asking for and that might be his civil case witnesses. I was asking for the document from Steggy that lists
on the call at the end of the article. I think where he was talking about, he put together that financial exhibit of statements of like the balance, and he had it in a civil case. When Matt was talking to Roger on the phone on that last little video we played. I think that's what she's talking about.
I don't know that I have that. I know what she's talking about with Steggy and his long list of people that he was gonna, including the wives.
Well, it's good to have the witness list too, though.
I'm looking for it.
All right.
Thank you.
Again, folks, you can call in at 702-482-8620. We'd love to hear from you if you want to ask a question or make a comment. We're going to be wrapping it up in about 4 minutes, though. Oh, it's been a long week, but a productive one, to say the least.
Yeah. Did you guys get that email from Barbara Stone?
I don't know. I doubt it.
About the Breslin murdering Roger.
Checking.
I'm looking at mine. No.
I don't see. Do you think that's her YouTube video?
No, it was an email. I'll forward that to you too. I'm just looking first.
Our precious networker. Thank you. Stalled out.
I'd like to see that too. That's interesting. It's a lot of.
I'm working.
Amazing times, don't we?
What's that?
I said we live in amazing times, don't we? I mean,
we really do.
Considering how things played out the last 3 years and where we are now compared to where we were then, I mean, who would have imagined we'd be here now fighting freaking communism in our own country?
I know. I'm just so mad that people aren't being held prisoner. That's
Right.
what's making me angry.
It's not right, man. It's not right.
No. My mom's a prisoner of war. I mean, Christine's dad, Roger, so many people. It's so disgusting.
Hi.
Does that ringtone ever startle you? I know it would me. All right. Well, we're gonna have to wrap it up because it's 5:21.
All right, you go
Folks
get
out
your.
before they close, and then I
Yeah,
got
well,
to dinner.
all right, we'll talk to you soon. I'm gonna send that as soon as I find it.
Thank you, Alan. Thank
All
you,
right.
Steve.
Yeah, thank
Have
you
a good
guys.
night.
Help me share out the live too, folks. Appreciate it.
Thank
And
you.
that goes for all of our viewers too. Help us share it out, folks.
Thank you, Steve.
For watching. We appreciate you.
Like and
everybody that watched. Thank you, everybody. Good. We will be back soon with more updates as well. For now, good night, and enjoy the article and the